Thanks.
Thanks, Mike. All right, we'd like to start the meeting. Good morning, everyone, and welcome. Today is January 19th, 2016, and this is a regular meeting of the members of the New York State Liquor Authority. In attendance is Chairman Bradley, Commissioner Kim, staff in attendance General Counsel Flug, CEO Bryan, and myself, Acting Secretary Held. The next meeting dates are set for Tuesday, February 2nd and February 16th. All meetings are held in our New York City office with video conferencing available from our Albany and Buffalo locations. Items will be called and the orders are signed in, first in Albany, then Buffalo, then here in New York City. When your matter has been called, please approach the podium and state your name clearly for the record. Please note there will be no oral argument on any matter where a 500-foot law hearing was held or a full disciplinary hearing was held by a hearing bureau. We do ask, matter of courtesy, please silence your cell phones. Before the first item is called, General Counsel has an announcement she'd like to make. You're up.
Okay. A portion has been added to the SLA website under our Register a Complaint tab. We have now included information on how licensees in all tiers can self-report violations and the consideration that will be given to those licensees who self-report a claim. Additionally, Chairman Bradley would like me to announce that the advisory regarding private collections has been put over till April 26th.
That's it.
Okay. Good thing I took a note. All right. On to Buffalo. The first item is 197, Elmwood Village Liquor.
Good morning, Paul and Antonio.
Has the DBA violation been fixed?
You're doing business as name? So the sign that was outside of your premises?
Oh, yeah, that's been removed. That was removed back in June.
I'm fine with this.
I am too.
All right. So you have an offer of $5,500. I accept.
I accept.
Thank you.
Thank you.
Okay. I did say I was going to call Albany first. There is no one in Albany. Correct, Cindy? I'm sorry. It's creature habit here.
That's okay. No, there's nobody in Albany.
Okay, we'll close off that. We need the resources, so. Okay. Next item in Buffalo is 140. Kays Hassan Al-Madari.
Morning.
I just got her email.
Attorney Roman Fontana appearing of counsel to the law office of Nelson Torrey for Mr. Al-Madrahi.
Where is he?
He was supposed to be here, and we've had some traffic this morning, and I don't know if he's been held up in that, but
Recall it?
Yeah, we're going to recall that. I'd like to see him.
okay.
226J, Stonewall Wine and Spirits.
Good morning, I'm Eric Millen.
Yes, that one. Do we have any protesters over there?
Not to my knowledge.
All right.
There's no opposition present.
Thank you. So you used to be the co-manager for Judd Falls,
That is correct, yes.
and they're the closest store to your proposed premises.
I believe so, yes.
And we didn't receive any opposition from them nor any of the other stores in writing at our offices either.
One of the questions I have is why so big?
It just happened to be the only available property in the area that I was trying to target geographically. The landlord's been extremely helpful and he's been sitting on that empty for, I believe, almost 2 years now. So we worked out a deal to hopefully both of our mutual benefit.
So the retail space is going to be almost 3,600 square feet?
No, the retail space is going to be about 1,700 square feet. There are going to be offices and stock rooms also on that floor that go toward the 3,500.
Is that what you have?
No, they wrote in the establishment questionnaire that the first floor retail space would be 35 days.
Yeah, you're going to need to at least amend your application after this?
Okay.
to reflect the office space?
I know, I see that.
Oh, he said 1,700.
1,700 retail space?
Correct, yes.
All right.
All right. Given that the three closest stores have robust sales, all increasing in the past 3 to 4 years, and with your experience as having been a manager at a package store previously, and your representation that your retail space would be 1,700 or so, I vote to approve.
I'll approve as well. The closest store is, it appears, over 4 miles away according to our records, and you also have committed to doing tastings of New York products.
Yes.
Go ahead.
I was just going to say, absolutely. I have good contacts with many of the local wineries, and we look forward to having them feature tastings.
And as Commissioner Kim pointed out, the sales of the stores that are quite a distance away are all improving at any rate, so I'll vote to approve.
Good luck. Good luck. Thank you.
Thank you very much.
226I, Grill Yard Foods.
You've seen this one, right? Oh. Yeah, it's this one.
Good morning, I'm Jason Schmidt. I represent Grill Yard Foods. This is Christopher Kubasik, who is the sole shareholder and the applicant, and this is Robert Heil, who assisted us with the application.
I mean, this case came before us, not exactly in this form, but, you know, we have a history with the applicant and his ex-wife, whose license was canceled just in November based on availing charges, and also there were issues of character and fitness. I'm not exactly sure what's changed in the last couple of months that you expect us to review this application and approve it based on the method of operation and the applicant principal for this application, who happens to be the same availee of the previous license.
Well, if you look at the issues that arose with the previous license, that was in the name of Karen Kubasik, and this was a mom-and-pop shop in which mom and pop had a very lengthy and protracted divorce proceeding. And there was quite a bit of confusion during that process in that there was a bankruptcy court involved, the divorce was pending out of state in the Commonwealth of Pennsylvania, and that the court handling the divorce issued orders affecting the establishment. So did the bankruptcy court, and those did not comply with New York laws, and so there was quite a bit of confusion. The resulting settlement between the parties that gave rise to the current application is one where, as part of the property distribution, Mr. Kubasik was prepared to purchase the business, and he has taken quite a bit of steps to renovate the business and to form a New York corporation, of which he is the sole shareholder. I would point out that if you look at the history here, you're talking about license-related offenses for the most part. You'll see that in terms of operation of the premises, it was a very responsibly operated business in terms of any alcohol-related offenses. I think in the past there was only one offense related to the service of alcohol after 2 a.m. To a band member, which was quite a number of years ago. Mr. Kubasik himself is somebody who, is a fairly reputable individual. He's a volunteer firefighter. He's a lieutenant with the fire department. He has 15-plus years of management history. You're talking about an establishment that has a storied history on the Lake Erie Wine Trail. It goes back to the early 1800s, 1804. Abraham Lincoln was there twice. I would just ask you to take into consideration that this has been a very difficult time for all of us, and in particular Mr. Kubasik, in dealing with the divorce situation, but we have put that behind us, and we have believe that we had paved the way with the settlement and the relinquishment of the prior license for Mr. Kubasik to come in and to legitimately run this business.
Are you saying that the information I have, it appears the availing happened from the inception of the license, that he was an equal partner from the beginning?
I believe that the initial license application listed the two of them as sole proprietors.
Is that correct?
And then there's, when you try to go back, and then there appears to have been some confusion in that Karen was put on the license, and they were they were attempting to obtain small business loans and associated with her ownership of the business as a woman here in New York State. And then the communication it broke down between husband and wife, and then it devolved into a very protracted, ugly divorce battle. And meanwhile, you've got a business that
The first license was put in Karen's name only.
Yeah, the first license was only in the wife's name. Yet he was an equal partner from the beginning.
2005, when we first applied for the license, we applied with my name on the license until we spoke with a person, I believe in the liquor authority, that stated that I could not be on the license due to it being a sole proprietor. But I believe they did a background check and fingerprints in 2005.
Well, that's not, one, that's not the case, and two, that's not really the issue. The issue was, if you're going to be an equal partner, you got to be an equal partner on the license.
I don't think anyone intended to deceive the liquor authority in the application, and in any event, you're in a position now where finally Mr. Kubasik can legitimize the license and the business. I think, again, if you look at the history here, I think you'll see, even in the file, you'll see that there was a bankruptcy order out of the federal courts, out of state.
I'm not disputing any of that. My problem is that it appears to me that they were less than honest with us from the get-go, and maybe it was to get business loans because they wanted a woman-owned business. I don't know the reason, but now you're asking us to actually trust him when the only thing we've ever gotten from him was dishonesty.
Well, I would ask that you recognize, though, that Karen Kubasik is not the applicant here. She is completely removed from the business, and that this is now Mr. Kubasik's business.
Well, that doesn't really sway me.
What we had for Mr. Kubasik was a personal questionnaire submitted showing who was the landlord.
So let me ask you this: why you're telling us someone at the liquor authority told you not to be on the license because it was a sole proprietorship?
It was back in 2005, and I recall that's exactly what the lady had told us, because it took forever to get the license, and we kept calling every week. And she says, well, there's some problems with this, you're going to need to change this and change that, and that's what happened.
Oh, that doesn't.
But that was in 2005. That's.
Do you have any questions?
Well, I mean, the other concern that I had was that, as Mr. Schmidt, if he's practiced before us, would understand, we do like to try to give people second chances and opportunities wherever possible. In 2009, he was convicted of a DWI, and then again in 2012, convicted of DWI or DUI in Pennsylvania, and then with the other history that's here, that alone might not be enough to say that I'd have concerns about granting a license to someone with that kind of a history, although in many respects that alone could be enough, but given the other issues that have just been raised, I just can't see granting a license at this time.
I just would point out that the most recent violations that led to Karen relinquishing her license, when you really look at some of these issues, there were 3 allegations. The first one was, and I'd like to go into them. you're dealing with an individual here who has invested quite a bit into this business to renovate it and to reopen it. They're doing business now. He has, it's his livelihood. It's supporting his ex-wife and his son. You know, and to shut him down now would just be such a hardship. When you look at the underlying violations, you'll see that, for instance, you know, the first one dealt with when they had shut down for an approximate 1 month period when they were doing renovations last year. And then you see some statements that Karen had apparently made at a time when Chris and Karen were not communicating, and that my client really shouldn't be imputed with any of that. And then lastly, there's the license not being properly transferred because there was some recognition that Chris was running the business. And again, that just goes back to the confusion between these parties. When you have a bankruptcy court that's ordering the licensee, the prior license holder, Karen Kubasik, out of the business and directing my client to be in there so they can sustain the operation, it definitely ran afoul with the New York State liquor laws. So I'm just asking this group and the authority to recognize that Mr. Kubasik is trying his best now on his own to legitimize this business, and he's invested quite a bit.
Who's the landlord on this building now?
I am. I own the property on the building.
And it wasn't, I mean, you're telling us that it was closed for renovations, but there was a for sale sign on the building.
Yes, we wanted to sell the business because we thought that would settle the divorce, sir.
Yet you kept your liquor license.
Yes, that is correct.
I don't know.
No, there was quite a bit of maneuverings during the divorce proceedings. I wasn't, you know, the attorney on that.
And we recognize that in a divorce proceeding, a lot of stuff happens that is out of your control, but we have here on record that all of this was occurring way before the divorce. The availing occurred then. And then does Karen still have an interest in the property as well?
No, there's a settlement agreement between the parties, and she does not have an interest. That's the precursor to their divorce.
How many rooms are in this hotel?
It's a 2-room facility with a restaurant and a bar. Mr. Kubasik was the individual, right now, Mr. Kubasik is the individual who's running the place altogether, but he was running the restaurant while I believe Mrs. Kubasik was running the bar. Is it?
When was this settlement about the property taken care of? What date?
It hasn't been transferred yet. We're currently transferring the property.
Okay, so she still is the landlord then?
I believe there's a document there with her signature on it, yes.
That's what I had asked, who was the landlord, and you told me she had no interest in this building.
There's a settlement agreement in the divorce in which she, you know, relinquishes her interest, but they have not.
But the settlement hasn't been signed yet, right?
No, there's a written settlement agreement between the parties, so there's a contractual obligation on her part. It has not been effectuated yet because it's part of this entire process. There's finally some order and structure to what's occurred here. There hasn't been. I mean, if you look inside your file, you'll find that Karen Kubasik had contacted the authority on her own. She apparently was looking to relinquish the license. There was all kinds of, I don't know, shenanigans going on that we weren't part of, and that's finally resolved itself. Quite an investment has been made by Mr. Kubasik. He's replaced.
No, we understand the investment part, and the only reason why I'm even considering this is because of the relatively clean operating history and the hardship that it's going to cause. But you know, given these set of circumstances, again, the convictions for the DWI in the past few years, 2 of them, as well as the availing charge, which was upheld, And the record that we have that he was part of this from day one, which he also admitted to today, and saying that it was somebody at the SLA who told him not to get on the license because it was a sole proprietorship. I just, based on those set of facts, it just makes it very difficult for me to approve this, although I've been looking and trying to consider giving that additional chance. So I have to vote to disapprove.
If you're looking at approximate 10-year history of this establishment and you see only one alcohol-related offense for the establishment, I think that does speak quite a bit.
It does, which is why I gave it this much consideration. I think without that, it would have been a denial from up front based on the set of facts that I had before me. I don't know, Chairman, if you have something different.
You know, I mean, my problem is that they were availing from the inception of this business, and even when they got married, they didn't change it.
The whole purpose of this application was to clean all that up.
Can I speak, sir?
I understand that the point was to clean it up, but we were lied to from the initial application, and it's very hard for me, given the history here as well as his criminal history, to believe that that's going to change going forward. So I'm going to vote to deny as well.
This is a 200-year-old establishment in a small community that the community of Ripley depends on for the restaurant aspect of it. We don't do even quite $60,000 in business a year. This is a truly 200-year-old establishment. Abraham Lincoln was there twice. He campaigned off the train. It's the first stagecoach stop in New York. It is historical. It needs to stay in business. I'm doing the best I can. I have to say that I don't have a law degree. We probably made mistakes, and we should have inquired in an attorney, but with a small business, you try to handle things yourself and hope you know and do the right things, and it's very difficult. And that was in 2005, before we even knew what was going on as far as the liquor laws, the liquor authority, and all that. And we read it, and we did what we could. And I beg of you, for my son and myself and our family and the community, to please approve our license. I will guarantee you that there will be no issues with the liquor authority. We're very responsible people. Please.
But see, that's the problem is you haven't been responsible. That's the problem I have, is that you have not been responsible. You appear to have an attorney now who is trying to straighten this out. I can see that, but when the option was given to you to tell us the truth or lie to us, you lied to us. And then you continued to lie to us for, you know, it sounds like you got married in 2006, so at least for the next couple of years you continued to act like she owned this business when in fact you were sharing it with her. So I continue to vote to deny.
I vote to deny.
I just ask you to take into consideration, again, you know, the responsible ownership in terms of service of alcohol. I think that's a very good track record, and that's, you know,
it is, and as Commissioner Kim said, that's why this has taken so long. Because I did consider all of that when I reviewed it, as did he, as he mentioned. So, you know, that otherwise, the availing we take the availing here very, very seriously. And, you know, it's very hard to overcome that, and I don't think that he has, so.
Thank you.
Thank you.
226H, John and Esther Huntington.
I've got that one too.
Okay with this. Make it quick. You have any questions?
Nope.
I'm
But I
John
do have
Huntington.
one.
Oh, go for it.
And I'm Esther Huntington.
And I'm Mary Dorsanio. I did the application for the Huntingtons.
So, Mr. Huntington, you owned, just because we don't have a lot of records on it, you owned a restaurant previously?
Well, I had the settlement back in 1979 for about 7 years, a bar room, food place.
And did you ever have any issues with us with that?
No.
Okay, I'm okay.
Okay, the closest store is 7.5 miles away. 4 out of the 5 closest have had increasing sales. The third closest is only 550 square feet. You're proposing, how big will your retail space be?
I think it's around, about 3,000 square feet maybe, or.
But you have your total area is 1920.
Oh, okay. 1920, the whole area.
That's your whole area, so if you have 3,000 retail, there's something else that you're not telling us?
You put it in the backyard?
No,
I'm sorry.
No.
I didn't hear what you said, I'm sorry, my apologies. What's the question?
Wanted to know how big is the retail space gonna be? Without the storage. 900 square feet.
About 900 square feet.
900 square feet, okay. And given the 900 square foot retail space, I'll vote to approve.
I vote to approve as well on the same grounds.
Good luck.
Thank
Thank
you.
you.
Thank you very much. Thank you, Ms. Michelle.
Okay. I'll recall item 140 for the Quick Shop. Did the applicant, or I should say licensee appear?
Yes, he's there.
State your name again, please.
Yes, my name is Kaisal Madrahi.
Roman Fontana appearing on behalf of Mr. Madrahi of council, Mr. Torrey.
So, Mr. Al-Madrahi, you were cited for the same violation back in March 2013, and I think at that time, hopefully it was made clear to you that the way you were keeping your books and records, which basically was none at all, was not in adherence not only with federal and state laws, but also with the SLA laws, ABC laws. So what's going on here?
Since that time, Mr. Madrahi has conformed his practices in conformity with the law in that he has he's actually put his brother on the payroll. He's taken more time to do his books himself, and I believe, according to the statement of mitigation, was there a statement of mitigation received by the board?
You have it?
Statement of, mitigation right here.
Yeah.
Yes, we did receive it.
Okay, that recounts the history and what's been done since then. Mr. Madrahi's financials, quarterlies, and 2014 tax returns have been filed and provided to the board. I'd requested it be noted that the area in which this Quick Shop is a deeply economically depressed area with very little business coming through. Mr. Madrahi and his family are all co-located in the same building, and they help each other in their business, and believe that based on the violation that he was cited for, all of the issues related to that have been resolved in the production of records and quarterlies and invoices for non-alcoholic products. So his business practices have been conformed to meet the state requirements.
Does he have a bank account?
I have it right now. I'm subject to put a new one.
He had his previous bank account was closed due to a negative balance because the area that he is operating is so depressed. I believe he states that he presently has not been able to reopen a bank account.
I'm not following you. He can't have a bank account because the area is depressed?
No. His previous bank account, his business bank account, had been closed due to negative balance, so the bank wouldn't allow him
Which
to
means he
reopen.
wasn't using it.
I was using it, but it was like too much transaction was more, and money is supposed to put in there, and I was trying to put money, and they closed the account. When I tried to go reopen it, they say they can't. So I'm trying to open now.
So what are you doing with the sales tax you collect?
I pay it like filing quarterly and
how
by check money order.
So he stated that he's paying his sale. He files quarterly, and he's paying it by money order, check.
And how's he keeping track of the sales tax he collects? Because it appears he doesn't bring anything up.
I get the bills and to accounting, and he described how much we bought to to the sales tax.
So,
Guessing?
No,
No.
he do the account, he do the sales tax. When I give him all receipt for my purchases, he do the sales tax.
so he's stating that his accountant, he keeps a written ledger, so his accountant takes the sales and based upon what's been sold, calculates the sales tax and remits a check or money order to the state.
So you're telling me he has no register tape or anything of that nature? He writes all a handwritten ledger?
Cash register.
Yeah, now I have a new register now to keep all I make in a day and save it for from now to keep my business going.
So previously, there was a ledger. Now he states that he's got a cash register that calculates and tallies the sales tax. So the issue.
What happens to him if he lies to the New York State Tax Department?
Say again?
Is he aware what happens if he files false sales tax returns?
Well, I'm not sure if my client has a specific knowledge of the law. He knows it's required, and these issues that were brought up during the violation process have been remediated. So he's saying that he got a cash register. He's now following that procedure so that there is a methodology by which the state can look at what his current sales are, and he can calculate. It's done daily now.
Well, here, go ahead.
No, I don't have much to say.
Do you have a fine you want to do, or?
Huh?
You want a fine?
Yeah.
Okay, go ahead.
So I think this is really the last time, based on this charge, that he should be before us. So I will impose a $4,000 fine.
How much?
$4,000? Would you have more?
No, I'll agree with the $4,000 fine, but I would go have a conversation with him because I don't believe a word he's saying right now, and they're going to be in there shortly.
Okay. Thank you.
Is that a direction to enforce?
Yeah.
Is there anyone else in Buffalo?
There's no one else in Buffalo.
Thanks, Michelle. 195, 21st Street Entertainment.
Great. So I think I'm going to recuse myself from this.
So I don't know where that leaves you or what you want to do.
I have no choices. I will make my application to you, sir.
Okay.
I would say go first, it's Kevin Dano for the applicant, Dano McMullen and Panoff. Second, I will say good morning to Commissioner Kim in the morning.
Good morning.
Sorry to hear you're recused, and my other question is, do you want to hear the opposition first, or do you want to hear from me first?
Yes, we'll listen to the opposition first. Thanks.
Good morning, Commissioner Bradley, Kim, Ms. Flug, O'Brien, and Held. My name is Pat O'Brien. I am the chairman of Community Board 2, which is the community district within which this location is situated. We have a very long history. This is now the third application for a license brought before the authority. Each of the prior two were denied. And I trust that you have before you my letter of October 28, 2015. I think that pretty much says it all. One change I would like to make, I noticed that I made a reference to this as a 500-foot rule hearing. That's an error, so I trust you will disregard that.
Yeah, I did.
But without belaboring the point, I am disappointed and frankly upset that this applicant, who is the owner of an establishment in the Bronx called Sin City and the owner of the building where this location is, and who has certain business and other ties to some of the principles of the previous applicants, would waste your time and that of our community and the taxpayer resources that are attributable to those things to make this application in the face of two prior rulings of the authority that indicate not simply that the principles of the prior applicants are not of suitable character to possess this license, but the actual location where they propose to license is not suitable. They have not listened to the authority.
Can you just put on the record why you believe it's not suitable?
Well, the fact is, the appellate division has found that to be so, and so has the authority twice. The substantive facts underlying those determinations are that the Long Island City and Hunters Point area of Queens, where it is located, have experienced a dramatic multi-million, if not multi-billion-dollar renaissance and redevelopment over the past several years. It is a community that is growing with families and uses that had not been there before. It had previously been largely an industrial community. And if anything, since we were before the commission several years ago, and this might go back as long as 5 years ago, at that time the finding was that the development was ongoing and this was not a suitable use. Since that time, we don't have investigatory resources as a community board, but we see all of the land use applications that come in. We have seen perhaps double again investments and commitments to develop the area. So if anything, we had this applicant into a committee meeting at the community board, and the most salient question we asked them is, what has changed from the prior applications and determinations to now? They had absolutely no response, zero response.
I'm sorry, were they represented at that meeting?
They were represented by counsel, a lovely person. There was a young attorney sent from an attorney's office, whose name I don't remember, who, in order not to lambaste her, I politely referred to as a sacrificial lamb. I think their counsel sent this young person in knowing that they had no ability to overcome the findings of the appellate division. But yes, they were represented by counsel, and I had communication even after that meeting with their counsel. But the only thing that really has changed from the first determination is that there is even more development, which was the basis for the initial denials. Something else has changed, though, and I have with me today to testify in opposition is Captain John Travaglia, who is the C of O of the 108th Precinct, which is the precinct in which this establishment is located. There have been numerous and repeated incidents.
Is he here?
He's here.
Why don't we let him talk about that?
Okay.
You can finish what you're saying.
Okay. But the other thing is that and this goes to, I believe, the character of this applicant. I don't know why I got one, but there was a mass mailing to folks in the community to support this very application. I received one at my home. And in that mailing, which is attached to the letter that I sent to you, is a promise to do something nice for anybody who registered their voice in support of the application, and to provide something of value, a VIP membership or something like that. I'll leave it to you as to the appropriateness of that and what weight you should give it. But from our perspective, that's dangling an inappropriate carrot out under the nose of people who could care less about what happens in our community, but only wish to frequent places of this nature. So,
I don't want to mischaracterize the letter. Is this what you're talking about?
I have an extra.
Because I don't know that it said anything about support. It was just basically inviting you to come in and...
Okay, let me, if I may approach, I'll show you.
And try the place.
Yeah, if I may. May I approach?
Yeah.
This is a copy of the letter. Here's a photocopy of what was mailed out. And the second page.
Okay, I see.
Is a request, we support the application.
Okay.
Okay?
But that's that's common in not just these types of establishments, but many. Whether it's appropriate or not, you can.
Exactly.
That's your determination.
Advertising is one thing.
But I don't.
This is something
hold it against anybody.
But I thought it appropriate to bring it to your attention.
Yes. Anything.
So I think ultimately, I am a lawyer, so I can speak from a legal perspective without having the background in this area of the law. That notions of res judicata and collateral estoppel apply here. There is absolutely nothing that has changed in the direction of favoring this application that would warrant a reversal of the SLA's prior determinations or that of the appellate division. And in finality, the only thing that has changed is that the underlying facts in support of the reasons that directly go to the location, not the principles of the application, have only been almost redoubled because there is that much more development and there is that much more of a change for the better in terms of what's happening down there between residences, businesses, and a real renaissance in that part of Queens, which we don't want to see reversed. I hasten to add, this location is almost the gateway into our community. When you come over the Queensboro Bridge, if you take the upper level, as you loop around, there is a traffic light. And this location is, it would be like a billboard coming into our community. It's directly across the street from that traffic light. And this would be what you see when you come into this new community. So that is our position. As to activity, I would, if you would, sure. Captain Travaglia.
Captain. Thank you.
Well, thank you.
How are you?
Good, good. It's Captain John Travaglia, Commanding Officer, 108th Precinct.
So what is your take on this?
Well, in regards to the location.
And I just want to ask you regarding police activity and things of that nature.
Right. In regards to the 108th Precinct, looking out, 75% of our shooting incidents for calendar year 2015 occurred in front of that location or a block away from that location. Look,
and when you say 75% of how many?
We're talking about three out of our 4 shootings. All right.
Was there any connection to the victims or the perpetrators?
February 7th, it was a bouncer's employee of a security personnel from their location was shot. 3 males were subsequently apprehended. Those 3 males just the 3 males were patronized the location. They combined had 90 felony arrests to their names prior. Gun was recovered, in regards, and that's awaiting trial right now. June 20th, we have a complainant victim that is robbed. He left the location. He's within a block away from the location. He's shot at 2 times and robbed of a $10,000 gold chain. Perpetrator is unapprehended, connected to the club that night. And then October 25th, 2015, we have patron leaving the club. He is shot approximately, half a block from the club, shot twice in the abdomen. $10,000 gold chain is removed from him, and a watch, and perpetrator is not apprehended at this time. He definitely was patronizing the club at that time.
The victim or
victim? Victim. And he's found to be in possession of approximately 20 decks of heroin.
The victim?
The victim. And like I said, he had just left the club. Overall, looking at the incidents, from emanating from 4250 21st Street, throughout the entire year, we've had 7 arrests within the vicinity, within the 1,000 feet radius from the location. 4 were definitely club related. We issued 7 C summonses.
What are they?
The C summonses were criminal court summonses from urinating in public, disorderly premise to the location, open container, urinating in public, open container, disorderly conduct, and another open container. And then various vehicle, approximately from the hours of, and this is just from the perspective of hours of operation, that these summonses were issued. We had 21 moving violations issued in the vicinity of that club. The index crimes that we had taken, like I said, I just spoke about the 4 index crimes there prior, and then in addition to those, I have 6 other complaint reports taken with the 1,000-foot radius from the club, and those range from, we talked about the first four: homicide, attempted homicide, assault, robbery, and then the other complaint reports that were taken were harassment, assault, 2 assaults, criminal contempt. There was an ex-boyfriend violation of Order Protection at the location. The other was a lost property which turned into a grand larceny, which was stemming from a lost wallet inside of the location. And then we had a perpetrator found to be in a felony possession weight of, and that was our victim from the shooting on October 25th.
And are you aware of any other police activity within the?
I am. The citywide Organized Crime Control Bureau citywide cabaret unit has had active cases within, in which they purchased cocaine inside from employees of the club. I don't have exact particulars on that. The one particular, though, that I always jumped off the page was with that shooting on February 7th of 2015, in which the 3 male perpetrators were arrested with the gun who shot the security personnel at the club. The Organized Crime Control Bureau and Narcotics Bureau, at that time, just the local module team, they, as a follow-up to that shooting on February 14th, sent an undercover in who was able to purchase marijuana at that location, just a week after the robbery, a week after the shooting in front of the location, back in February of 2015. Exact particulars of the further investigation by the citywide cabaret unit, I don't have all of them, but it was enough for us to shut the institution down under nuisance abatement approximately a month ago, which they've since met stipulations and have reopened.
And this is all without alcohol?
This is all without alcohol.
When did they reopen, do you know? Well, I'll get that for a minute.
Yeah.
Okay. Would you consider this a focal point for your precinct as far as patrols and things of that nature?
Well, absolutely. I mean, it's a focal point in, the fact that I've had 3 shooting incidents there out of my 4 from last year. So,
and how many of the 3, you definitely can tie one to at least the victim to you can tie 2 exactly to the location. Can you tie the other one to the location?
Well, the February 7th, like I said, security personnel was shot from the club. June 20th, statements from the victim that he was leaving the club with his sister, and then he was shot at and robbed of his gold chain, and that was a block and a half away. And October 25th was the male shot after he was leaving. Video was obtained there. Now, listen, in regards, the level, it's a focal point. There's no doubt there's violent activity that happens, and all the time is from that 4 to 7 a.m. period of time. So it's a very unique period of time that I know of, right, during their hours of operation. So I can, they're really the only thing open over there during that time period. There's no confusion, a block away from there is the headquarters for Rolex. For like the Northern Hemisphere is right there. So it's not coming from Rolex. Nothing's happening there. So, it's, and the bank, there's a bar around the corner from them, 5-Star Banquet. They're closed after 4 o'clock. So I know it's not coming from there, either. We right now are in the process, we have a plan in place right now where we're deploying vehicles with plate reader technology that are specifically fixed at this location, 1 block around, just scanning for license plates. That's 1 car a tour that I have to put there from about 1:30, 2 o'clock in the morning till about 7 o'clock in the morning.
And why are you doing that?
Just to make sure we're obtaining all the intelligence we possibly need because 2 of these shootings are unsolved.
Oh, okay.
So the idea is I can't be in a situation where we're lacking intelligence to solve the future. So, but my anti-crime teams, like I said, redeploy to that location 4 a.m. to 7 a.m. for the most part when they're available. You know, we're a very small precinct, you know, when it comes to resources. And crime patterns are very identifiable because we are a small precinct that takes a very small amount of crime. You know, we were the second from lowest in New York City for calendar year 2015. So these type of acts of violence.
Two unsolved murders or two unsolved shootings are a problem for you.
Right, right. So.
Okay, thank you.
Thank you.
Again, Kevin Dano for the applicant, Dano McMahon Panel. So, first let me point out that when the captain talked, everything he talked about took place from, at least most of what he talked about either took place outside the club, away from the club, so we're blaming the victims here, you know, because...
Well, I don't know that he's blaming any victims.
No, I'm not saying he. I didn't say he.
I was asking because I'm familiar with that area, and I know that there's not a lot of activity in that area at night.
Right.
So I would agree with the captain that
so do I.
That they were the targets.
So, no, I'm not denying that.
Okay.
What I'm suggesting to you is, from 4 o'clock in the morning until 7 o'clock in the morning, is because this club is open from 4 to 7 because you didn't, not you, because they don't have a liquor license. If you gave them a liquor license, they'd be closed at 4. These incidents were...
You want me to give them a liquor license to shut?
Yes, I do. It's not as funny...
It's a unique argument.
It's not as funny as it seems because the point is, I have other points, but the point just to address this is that a lot of these problems would be resolved if you gave them a liquor license, because by giving them a liquor license, they come under the liquor laws, they close at 4.
Or all of this just moves earlier.
Well, but the captain's discussion was that this is the only place that's open. And by the way, the first shooting that he talked about, and I really want to go on to other things, but the first shooting that he talked about, first we were talking about a new owner that would change some of these things, which I'll talk about also. But the first shooting he talks about, security guards evicted these people. They came back after the club and shot the security guard who evicted them. They're doing their job. The club, in that case, is doing its job. It is really, you forgive me, blaming the victim. They threw people out to maintain a safe club, and then the people come back and they shoot the guy who chases them out. And by the way, the security guards from this club called the police, also chased down the people. These were the people who were caught. They followed the people all around, called the police, and were involved in the identification and arrest of those people. They did what they're supposed to do. Second of the shootings took place around the corner. Somebody leaves the club and goes around the corner and he gets robbed. You can't really blame the club for that except that it exists. You might as well say that the people who get raped in Central Park are in Central Park. It's not, you have to blame the criminal for what the criminal does, and not the victim. All right? Now, I can't say much about this fellow who had the heroin except that there's no indication he was selling heroin in the club. They just caught him with heroin.
He just went there to carry it.
Well, you talked about, the captain talked about all these incidents. There was no incidents of sale of heroin in the club that were...
Well, there were incidents of sale of cocaine in the club.
So I am told, and I've never have any issue, to doubt the police. But what happens with those issues is they didn't tell the club.
Well, I'll tell you. It appears that on September...
No, I know now.
October and November, there were 3 sales to undercovers of cocaine in the club.
No, I am aware of that. As I said, first we changed...
Those sales, and are you aware what the hours were of the sales?
When the club was open.
Well, the club's open apparently till 7. These sales appear to have occurred at midnight.
I understand, but first of all, there'd be a new owner if you grant the license. And I will talk about what the...
But it kind of goes against your argument that the man with heroin wasn't there to sell it.
Well, you can't assume that the man with heroin was there to sell it.
I can't assume anything, but I can make logical deductions.
Small amounts of cocaine versus...
20 decks of heroin is not a small amount.
That's what I just said. You're telling me that the police went in and they had small amounts of, they caught people with small amounts of cocaine, and you are extrapolating from that this man who was shot, who had 20 decks of heroin, was selling 20 decks of heroin in the club, and that's not a fair extrapolation based on the incidents that you cite with small amounts of cocaine.
Well, a deck of heroin is sold for individual use.
Well, I have to tell you, I know very little about heroin.
20 decks of heroin is 20 single packets of heroin at $10 a piece, Captain, or 20? $10 a piece. I used to do narcotics, so I am familiar with them. Not in a literal sense. I used to do narcotics cases.
Going down.
So I know what he was doing in there.
Well, in any event, there's no indication that the club owners knew about it, and when they did these things with the cocaine, they did not arrest the women that were selling them, and they did not call it to the attention of the club owner. So, you know, that makes it more difficult for the club owner to do something about it.
Well, is Julia Avila, was she an employee of the club?
I believe that she was a dancer and an independent contractor.
So she was working for somebody in the club?
She was working at the club, I believe. Okay?
Okay, go ahead.
Okay. First of all, I want to show you, I want to address for a minute the neighborhood. Okay? All right. This is what the club looked like. May I approach a little?
Yes.
I'm just going to show you something.
A lot.
This is what the club looked like before. This is what it looks like now. This is about a half a block, you know, halfway down the block. This is what it looked like before. This is what it looks like now. So, you know, just, even though Commissioner Kim has recused himself, I don't want to, as long as you can see.
Mm-hmm.
This is what the back of the club looked like before, and you can see that there's people just like kind of lying in the street. This is what it looks like now. This is like halfway up the street before. Well, not halfway, it's just next to it. Not much different.
Mm-hmm.
They beautified it a little bit.
But doesn't this all go, well, I'll wait till you get back there. Go ahead.
This is where that restaurant, this is where the man was shot, around the block. And this is what it looks like now.
So just for the record, it's clear that all those pictures showed improvement in the area, but what I was going to say is, doesn't that go to Mr. O'Brien's argument that this area is developing significantly and really this isn't the place for this type of operation?
Well, there's 2 points that go to that. First, the city of New York, in its wisdom, has decided that this is the place for it. They zoned this place and unzoned other places, and they zoned this place because this place is particularly commercial. As you saw those pictures, you see that there is not a housing anywhere really near this place. There is a housing project that is about a quarter of a mile away, up to the right when you're facing the place. But this is particularly in the middle of an area that is commercial. And the city, in its wisdom, has decided that this commercial zoning area is the area that they wanted. That has to do with their decisions. And so when you say this is not the place, it is the place. My argument with regard to the improvements, and my answer to Mr. O'Brien's arguments with regard to improvements, is that for the past 5 years, this club has existed there. And during that 5 years, during those 4 years, with the existence of the club, the area continues to improve. Now, in regard to the question that was raised the last time an applicant made a request here, you know, and the nerve that it takes to come back and make another request, there were 2 reasons that the license was denied the last time. First was the applicant, he's not the applicant anymore. And second was this argument that it was going to somehow hurt the neighborhood. Well, for 4 years, it's been there, and for 4 years, the neighborhood has not been hurt.
Well, the neighborhood has improved, but you don't know that it has hindered development at all. You can't make that argument.
You can't make the argument that it has.
No, I can't.
Because right next to the place, I mean, we're talking, these pictures I'm showing you are directly, you know, in the very close location to this place, and they have developed. So I think I can make the argument, because if you were hindering development, you'd see development in other areas, but you wouldn't see development adjacent.
I think it just goes to his point that this area has, for whatever reason, recently attracted significant activity in economic development, and there are, you would agree, certain businesses that don't want to be located near a strip club. No matter what the reason may be, there are businesses out there that would refuse to.
I would agree with that, but I would say to that, I would bring up a constitutional argument, because the Supreme Court has ruled that topless dancing, nude dancing is a form of speech and is entitled to the protections of free speech. Now, to be fair, the Supreme Court has also ruled that the 21st Amendment gives a state the ability to say, I don't want alcoholic beverages in these places. But our state did not make that decision. In fact, our Court of Appeals made the exact opposite decision. Our Court of Appeals struck from our statute those provisions that said that you could not have nude dancing where you have
But this isn't about nude dancing. He's already open.
Well, but there is.
I mean, I'm not telling him to shut his doors.
There is additional constitutional authority for the proposition that you can't withhold a license because of nude dancing, and that is exactly what I believe is being suggested to you by.
I don't think that has even come up.
I think that's what is being suggested. They don't want this kind of establishment in their neighborhood. That's the problem.
I think the police captain was very articulate in stating why that is, and it really had nothing to do with naked women.
Well, but that's the community board is what I'm talking about.
Oh, well, that could be. But they're not, as you know, it's not a 500-foot case, so while their input is certainly welcome, it doesn't necessarily rule the day.
I would also like to point out to you that the last meeting of this authority, you approved a license for the place Scandals, which is in the same neighborhood. It's a community board. It's a community board 1 rather than community board 2, but it's the same neighborhood. It's a block and a half, 2 blocks, 3 blocks away. So to say that this place is problematic, where you just gave a license, to a place in the same general vicinity
without the history.
But the history is outside for the most part.
Well, actually,
no,
as
it's
to
not.
Scandals, we have numerous police referrals for that incident, and they're being prosecuted right now.
Who, Scandals?
Yes, I believe so.
So, as you know, then they're going to be dealt with.
I don't know, but the problem is that it's the same. You have the same neighborhood. You have the same.
No, see, here's my problem: is you keep pointing to the fact that the history is outside. Well, the history's not outside. We have an undercover who made 3 purchases of narcotics from an individual who works there, and by all indications, if they hadn't arrested her, they could have made 100 purchases of narcotics. Not to mention that there was clearly what I would term a drug dealer, that was shot a short distance away from the club that had narcotics on him that, in my mind, he had to sell because it was packaged that way. And I'm sure he was arrested for intent to sell. I don't know that, but that would be the way I dealt with it.
They didn't. If they didn't, it was only because he was sitting there bleeding.
Well, no, that would never stop me, believe me. But he clearly had been in the club. Hold on. So you're talking about a club that has no alcohol right now. And in order to have alcohol in a club like this, there has to be some level of security measures which are not even indicative of a club that doesn't have alcohol now in this place.
So let me tell you what, again, if you grant this license, Mr. Mavros will take over the club. And let me tell you what Mr. Mavros will do that's different to address those prices. First, he will place security inside and outside the premises. He'll remove the sign that says all.
There's no security there now?
There is, but he will increase the security, and he will start to have people come in and do checks, as if without, in secret, as if they were like the secret police themselves, the undercover police, not the secret police. Please forgive me.
That goes way back.
Captain, please forgive me. All right, but there was no implication. He will do undercover stings of the unemployment and also search the employees coming in and out.
Are they searching anybody now?
I don't know.
As far as at least metal detectors or anything?
I don't know.
We just purchased.
He would institute metal detectors. He would institute electronic proofreaders. He would institute regular cooperation with the police. He would allow the police to do inspections and waive any kind of right of needed for a search warrant or anything like that. He'd independent monitors inside and out to make sure, both with regard to drugs and also with regard to health law and also with regard to the alcoholic beverage law. He would retain the services of former investigators from the SLA to do investigations with regard to alcohol. My suggestion to you, goes back to the beginning, and I know that it gave you a chuckle, but if you grant the license, they'll close at 4 a.m. They will follow all of the New York alcoholic beverage laws. They will hire people inside and out, to protect it. It'll be a safer and better area for the neighborhood. And with regard to those you had over 100 people that said that they want this place open and to have a liquor store, and they have a right also. They're also people. It's not just the community board. They're also people. And to the extent, I don't think you already said that you weren't going to hold that against it. No. But to the extent that it says to somebody, to say to somebody, if you approve this, you're telling them that these are people who actually say, I would frequent the place.
Right. I mean, and the community board does the same thing. They don't bribe anybody. I wouldn't use that word, but they don't try to encourage anybody to come. But they certainly go out and drum up support for their position. So I don't hold that against anybody.
I believe I have.
I mean, my problem is, and I'm very happy that the police captain came down here because we got direct information from him, and I was aware of most of the criminal activity that had occurred within the area, as well as the drug sales that had occurred within the club. But we got more specifics from him, and my problem with it is it clearly is just a focal point, and as the previous two applications indicated, at least that the board indicated in their disapproval of them, the area is clearly developing. It has developed as you showed through the pictures, and I do think that an establishment like this certainly can hinder that development. There are high schools, there's residential, there's hotels that are going to be built there, and to compound that, and that's not really the main reason, to compound that is the criminal activity that has occurred around and in the club. The 3 narcotic sales to a dancer at the club are really problematic for me. And just based on that, I think that I would deny the license, so I'm going to have to vote to deny.
I would just like to point out to you that those incidents took place before Mr. Navarros took over.
It's still a focal point of police activity. As the captain indicated, he now has a car that videos every license plate around the area in order to try to solve 2 shootings that he has directly attributed to at least patrons of the club as victims. So it clearly is a focus of the police department and a drain on resources.
Mr. Chairman, I thank you for your...
Thank you. Can we take a 2-minute break?
Yep.
Right now? Okay.
Roland and Frank.
I'll email Mike.
She would have came
To show. I'm gonna do many emails people send you throughout the day. So the husband has to look for, the wife is on this, is also a signatory on the Carver checking account. Ask him. Just ask him. You know, but then he writes, is that kosher? Why?
What is her involvement going to be? Does she have other
Yeah.
employment? It's just a signatory. Oh, it may bother county office down the line if she's signing for orders.
Well, it depends, yeah, I mean, but
Just make
is
sure
it
that she has
just
no involvement.
involvement?
Actually stood in front of this thing where they put the store in, and I could see the lights from my store.
Would like to start the meeting again?
I,
You want to grab a seat?
okay. Is he in here?
Are they?
Both are in here?
Yeah. Before I call the next item, the chairman has an announcement to make.
So, Mr. Frank Constantino and Mr. Roland Stewart, could you come up to the podium? So, ladies and gentlemen, why don't you put your names on the record?
Roland Stewart. Frank Cosentino.
So I have worked in government most of my career, which is almost 22 years, I guess, at this point, and been in several different agencies, and I don't think I've been in any agency that has had employees who have worked as long as these two employees have for the same agency. Both of these men, Mr. Constantino is celebrating his 43rd year with the SLA today, and Mr. Stewart is celebrating his 42nd year with the SLA today. So I want to give them a round of applause and thank them for their service. So if you have anything to say about the SLA, now's the time to do it.
Just been an honor to serve. Thank you.
Thank you.
I was saying to
Okay. Thank you.
Roland.
And we'll be celebrating in the back later. Thanks.
Okay, thanks a lot. Very much.
All right, we're rolling. Item 226E, 9th Avenue Saloon.
226.
It's the second one down. I had to move it out. They have a time constraint. Oh.
So before you get started, is anybody here from the community board or the community? Okay, go ahead. We did get a letter that we have reviewed from the community board, but I'll let you go ahead.
We haven't seen that letter if it's, I don't think it's in the,
It pretty much just reiterates.
Rehash, all right.
It doesn't, there's nothing new in it. It maintains their previous position.
When we were last here in November, the board, and I want to thank the board for approving the alteration application, but they asked us to go back and look at the sound situation at the premises. And we reached out for a company called Accusalog, and they gave us a 10 or a 12-page report, which the SLA, I think, has a copy of if they...
Yes, we do.
Okay. Under that...
Oh, no, do we?
Did you get anything?
No, I don't think we do. Can you hand that up?
Of course, I stuck some extraneous material to it. That has 2 extra pages.
Okay. Oh, we can just share it. Go ahead. No, go ahead. We can, okay. Okay, go ahead, continue.
And that report shows that that the noise complained of does not emanate really from Rudy's, but it's from the 9th Avenue area in general. They made studies, and the complainant, it was reported that the complaint could not actually register the amount of sound that they accused from coming from Rudy's. And I gave 2 pictures today, which are additional from the old pictures that we showed. But one shows the addition of a of a drape, plastic drape, and the other one shows the, a canvas covering over the backyard, which we think will, again, reduce the sound in the backyard.
That's new, that plastic covering?
Yeah, as far as I know. And you have a picture?
Yes.
One, it covers the corner. You'll see there's windows behind it, and it doesn't show too well on the picture. But it goes from the top of the building to the backyard. And the other one shows the covering over the backyard. It doesn't show the whole covering, but it covers the whole backyard.
Situation, it is not presently covering the whole backyard.
This is here.
Yes, but
This is what we're showing now.
Okay. Do you have any questions? Who's the gentleman you have with you?
Feinstein, he's the man from Log. I can't pronounce it.
Oh, he's from the sound company?
Yeah.
Oh, can we talk to him?
hello, Al Firestein, Acoustalog.
So, can you just explain what, did you recommend that this stuff go up?
Well, let me explain. When I walked in there 2 months ago to do my first evaluation, there was already a canvas tent that is retractable over the entire space. However,
That's this?
well, they have two things. They also have a Lexan.
That's what he's showing.
They have three things that could block sound in varying degrees, ranging from a little to a lot. A lot is the Lexan, which is basically bulletproof plastic cover over approximately 1/3 of the backyard. The second thing that they have is plastic strips, which you can see hanging in front of a window with bars on it. I don't know if you have that
Yes.
picture.
Yep.
Right? Those also block sound a lot because they overlap and they provide a barrier to airborne sound. The third thing they have is a retractable awning that comes out, in and out. That does not reduce sound a lot. So what I'm recommending is that they put similar strips like the vinyl on top of or in place of the canvas. That will make them much more soundproof.
Why not just put something solid that would be soundproof rather than strips? How do you do strips?
Well, there's already a canvas.
So you put them on top of it?
Yeah, sometimes they get woven in with a little bit of overlap.
Oh, okay.
We did that at 60 Thompson Street, which is a
Right, yeah, I'm familiar
kitty
with
chai restaurant downtown. Works very nicely. But if there's a weight issue, because this is somewhat heavy material, it weighs at the minimum a half a pound per square foot because that mass blocks the noise, then they either have to reinforce it or come up with a different solution. So I've recommended that they look into two other possible alternatives, which they have, and they have one price on one of those alternatives already. One of the alternatives is to put in what's called a roller cover. You probably have heard about these things. They're retractable skylights, basically. They have them on top of the Empire Hotel, 61 West 62nd Street, which are very effective when they're closed. The next thing is to make their own custom roller cover, which would be like a telescoping awning similar to what they have, but made of pieces of Lexan. So it would be one side would move out, next one would telescope out from that, and so on. And again, it's Lexan, so it would be highly soundproof, as long as they are reasonably close to the walls. And then finally, I recommended to put a sound-absorbing material on the walls so that the sound that bounces around in the courtyard, which tends to build up and make things a little bit louder, which can then leak out and disturb some, but not most of the neighbors, is an absorbing panel called sound silencer panels. They've gotten prices for that, as well as a frame to hold it, because unfortunately, they don't own the walls on either side of their back courtyard, so they can't really attach anything onto there. But they've been down to my office. I've spoken with their designer, a guy named Lusan, who's looking into the custom making the telescoping enclosure. I told them to also get a price from Roller Cover. These are pricey items. They're in the tens of thousands of dollars. The material itself for the sound absorption is not that pricey, but the frames to hold it are. So that's what they're doing.
Okay.
When you say, even with 105 people in the backyard, the sound level would only be 5.8 dBA more sound than 28 people?
Yeah.
Can you kind of give me an idea what 5.8 dBA would be?
Sure. Well, normally if someone's talking to you and they're 3 feet away in a normal conversational tone, the sound level would be 65 decibels. But because 65 decibels is based on a scale that's logarithmic, if you had 10 people, just like me, talking each with the same level that would individually be 65 decibels at your ear, or if you had a sound meter right at your ear, it would go up 10 decibels. So it would go from 65 to 75. So you have to multiply the number of people, assuming they're all talking equally, by 10 in order to get a 10 dB addition in sound, a 10 decibel dB addition in sound. 5.8 decibels is roughly half of that. So it would be, well, say roughly 3 or 4 people. Not 5 people, because it's logarithmic.
See. So what recommendations then are going to be adopted? These are just recommendations that were made, correct? And no adoptions have been made yet. Is that correct?
Yes, except in the sense they have adopted my recommendation to figure out the pricing on one of these retractable covers. They have come down to my office with Lusan, who I've met with twice.
So is that something that they're definitely going to do?
The estimate that I've seen is
Go up to the
$120,000.
podium, please. Sir, just go up to the podium, sir.
The estimate that I've seen is $120,000, and that's an awful burden on and especially if they are still limited to 28 people in a backyard. I mean, it might be different if they were getting 66, or which was what the C of O says they can have, but without that, what we've done here has reduced the sound substantially, I think. Maybe not quite.
Would you say substantially, sir?
Well, I don't mean to be difficult, but no, what's in there right now didn't reduce it after I came. It was already there.
Right.
Okay.
Right, so nothing's been
We're working
done
on
in
getting-
addition. Exactly,
we're working
that's
on
my
getting it
understanding, correct. So nothing has changed since we last saw you. You can't say that what's there now has somehow lowered the volume of sound if nothing's been done differently.
Well, when the soundings were taken, and I understand they were not taken with the Lexan draped down or with the canvas top closed. So in that sense, we think that we have reduced the sound somewhat.
But they were always there. So you're saying in previous times when events were being held, those drapes never came down, and that's the difference, now that you'll just put them down?
The awning goes back and forth.
Right, but the awning, we just heard from an expert, doesn't really do much for the sound. He's the expert. I'm not telling you that, he's telling me
All
that.
I'm saying is that, the establishment has been accused of being noisy in the
Sure.
neighborhood. Now, and I'm not saying you're suggesting this, but the suggestions for reducing the sound, which I'm not so sure my client should be stuck with.
Who
That
should?
as it may.
Who should be stuck with it?
Well, I don't know if he's guilty of any excess sound because somebody in the neighborhood complained about sound.
Well, that's not really the only thing that went on here also, that we had, and correct me if I'm wrong, counsel, but didn't we have an extension of premises here?
There was the issue of the alteration.
That they
whether the
altered it
alteration
without
was
coming to us first, or the community board, so nobody had any input into this, so now you have it, and we're letting you live with it. But they have a right to say that we wouldn't have done this had we been given the notice, which is what they're saying. So now we're trying to alleviate that problem by putting as much soundproofing in as possible. Now, I get 112,000 or whatever the estimate is a lot. But is that what the estimate is, sir, for the lining of the awning, if we put the lexicon on that, if it's possible?
No, the lining and the sound-absorbing material and the frame that holds it is much less than that. It's
How much is that?
maybe a third that price. But I do want to point out that something actually has been done. It's small, but it's consequential. They had speakers outside, and they had another speaker directly inside. And if you see in my report, I recommended they remove those speakers, which, even if people aren't complaining about music, the music tends to make people speak louder.
Right.
So by turning that off, that had to have had an effect. I can't measure it, though. So that was done since we were last here.
And we don't have any complaints since we were here, do we, that you're aware?
So we're not saying put in the 112,000, although I do recall when your client was here that he said he would take care of whatever sound issues that anyone had.
Well,
And then,
windows in.
right, windows, and that would have been much more prohibitive, I would think, and he agreed to that. But, you know, we're not trying to impose anything so onerous on him. But I think there are definitely measures that can be taken according to the recommendations, including lining the walls with absorbing material, sound-absorbing material, which would not be nearly as costly, but would be very effective in lowering the sound. So that's what we're asking for. That's what the community's been asking for. And I think we can resolve it if you tell us that you're committed to do certain of these recommendations that the expert has proposed.
There's two recommendations, There's two recommendations in that report, which are substantially less than the roller cover. The roller cover basically...
All right, let's put the roller cover aside. No,
We're not telling you what to do, we just want to see you do something.
Exactly.
And if something is done and a period of time goes by, then I would certainly revisit the number of people back there should there not be complaints.
That's all I can ask.
Right, so what are you going to do? Do we need to have you come back in and give us an update in 3 months? Are we going to keep coming back and forth until something gets done?
Well, Alan wants to say something first.
I just wanted to say that I was asked by my clients to look at all possibilities in terms of occupancy, and there was a number in the 20s, there was a number in the 60s, and in my report I put in information about a number over 100 people. Because as I explained to your very pertinent question before, it's not like that many more people makes that much of a difference in sound. But I am recommending that they do, at the very least, the sound absorption, and then see where we're at from that point. And then they're still going to have to get the price of the roller cover, which may be more affordable than the telescoping situation, which is the $120,000 we told you about before.
Right. So why don't we do this? Why don't we put it off for a few months and then you'll come back. And what we're saying is if you solve the sound problem and your C of O allows for 66 people, we would be open to allowing more people into the backyard as long as the sound isn't an issue. But as long as you just maintain what the situation is now, we can't do anything because the whole reason why we're here in the first place is because there are community members who are complaining about the noise. So we're just trying to work with both of you here to be fair as much as possible, without saying you have to do this, that, and that. But you have to come up with something to let us know what it is you're going to do, because I mean this is a great first step, but it's not really changing anything from why we're here we were here in the first place.
I have one other point.
Sure.
We submitted a pleading form with a proposed penalty of $2,000.
Yes, the attorney handling that matter has since retired, and that will be forwarded to the board soon.
All right. Are they asking for more, or do you know?
No.
We haven't seen it yet.
Oh, okay. I thought it would be part of this. Okay.
But, you know, I haven't seen it, so I don't even know what it's about. So we'll certainly, when it comes up, you're welcome to come back or put it on a time that you're going to be here.
Okay.
When do you think you might have any movement on your?
Let's give him 6 months.
6 months?
Yeah, yep,
Sure.
certainly.
Sure, please.
No, we don't want the CNC hanging around for 6 months. It's for the unauthorized.
My name is Danny DePamphilis. I'm the manager of Rudy's Bar.
Oh, I did.
My
Call him,
architect wants to speak, but before
Call him
that,
up there. Call him up to you. Okay, I'm sorry. Go ahead.
before that, I just want to point out that, and we are more than willing to do something to mitigate the sound. But if I could just point out, in my acoustic expert's report, he does show that if we did nothing, that the increase in sound between 28 people and 105 people is negligible.
Yeah, he already brought that up.
Yeah, so in other words, there is a question.
I do question, I would say one thing to that, though. That's an assumption that the 28 people are talking 3 feet away, for example, in the example, or not 3 feet away, but in any type of a level of a tone. And if, when you put 128 people, 5x the number of people, there's much more likelihood that somebody in that crowd is going to be talking a lot louder. And it's a lot harder to control 105 people talking, the talk volume, as opposed to 28 people. So those assumptions are based if they all talked at the same volume. But given that you increase it so many people, I think there's a higher likelihood that there's going to be people that don't talk at the normal level. So the point is I think we just, unless there's another point you need to make, we just need, yes.
One more point.
Okay,
I just want you to consider that what's been said about the noise in Rudy's Bar basically emanates from 2 or 3 people in the.
No, we've been through that, so.
I know, but my point that I want the board to keep in mind is that, and we are going to mitigate as best we can, but the report by the community board, which is the basis for this issue, is 100% false. And my acoustic expert points that out. And I want to say, last time I was here, when I offered to put windows, and you said, are you sure you want to do that? And because you were thinking there were 400 bedroom windows, there's like maybe 3 or 4, not 300 or 400.
Well, trust me, if you offered new windows, all of a sudden you'd have 100.
Well, but my point is the report by the community board is factually, as my acoustic expert states, impossible.
But you also have to understand what they're doing, and they live in a very problematic area for bars. Their lives are disrupted by bars in that area because of the recent increase in, not recent, but I guess over the last few years. And they're trying to set a precedent for other outdoor areas which are being asked for in that region. And they have to, they want to treat everybody equally. And the problem here is that yours just ended up there and didn't go through their process. So you may be being treated differently by them. I don't know. That I can't tell you. But we're just trying to work with both people or both parties to try to solve it so that you can keep what you have, but move forward and try to keep them happy as well.
Okay, we are going to do this. It is going to be at a great expense relative to our little bar. But please just keep in mind that the acoustic expert does say that the ambient noise on 9th Avenue is greater than any noise of 100 people talking in Rudy's Bar is overcome by the noise of 9th Avenue, the ambient noise. So the people that are complaining are hearing, when Rudy's is closed, they're hearing more noise than when Rudy's is open. And also when Rudy's is open, they're still hearing more noise that's overcome the people in the backyard. My point is, please keep this in mind. I think it's a false issue that they're
No, and the report you gave us is certainly helpful, and then all we're asking for is a little effort
And we're willing, more than
And I'm
willing
not saying
to-
put a $100,000 awning in, but anything, certainly something, if you can show us something that we can show the community board that there have been efforts made, and we'll go from there.
Okay, well, I have one more question. When we do this, when we decide to implement A, B, or C, what first question is, does that require another alteration application on our part? That will go through the process? Number two,
No, I don't think so. In this, I mean, unless you're putting in something structural, but.
well, it would be structural in the sense that what if it's a roller cover?
No.
What, it wouldn't require.
Not with me, no.
Yeah, I think anything to do to mitigate the sound that doesn't have any other function, then I think we're okay with that.
I have one last question. That's great to know. That's great to know that. The last question is, you said you would consider the 66 people that our current C of O from the building department has. Would you also consider letting us extend our hour of operation, not on the weekend, but just during the week, 1 extra hour?
What are you at now?
It's midnight. No, it's 2 on the weekend, but it's midnight during the week.
No, Thursday you have till 1.
1, but.
What are you asking for, Thursday till 2?
No.
Sunday through Wednesday till 1?
I'm asking for this. I'm asking for Sunday at midnight. I would reduce that to midnight Sunday.
You have Sunday through Wednesday at midnight currently.
Yes, Sunday at midnight, and I'm asking for Monday, Tuesday, Wednesday at 1, and Thursday at 1:30 is what I'm asking for. And the reason I'm saying this, I asked for this.
Look, I think if you go and do what you need to do, and if sound doesn't become an issue, I think we'd be open to that. But first, you have to take those steps. We're not going to do it today when nothing additional has been done.
If you'd consider it.
I would, yeah. Yes, we would consider it.
Chairman, Commissioner, as to the disciplinary case 106728, a CNC has been submitted for $2,000, and counsel's office sees no reason to hold that.
All right, well, let's.
And I already looked at it, right?
No, it has not come to the members yet.
But I approve the offer?
We spoke, yes.
Okay.
I haven't seen it, but
We can put that on the calendar.
Yeah,
if
we
you
can
want.
put that on the calendar.
Jackie, can we put that on the calendar?
But the CNC memo has to be written up. The attorney resigned, and the new attorney will be sending it to the board soon.
So what do we need to do?
They need to
We
write it
need
up
a
in the next
CNC memo to go through secretary's
Oh,
office.
okay. All right, so we're going to put, it'll be on the next calendar and the one after that.
Why don't we just put it on
We can't put it on today.
No, he's saying when we come back for this.
All right, you can do that. Yeah, you can do that if you want.
Put it on March and we'll.
All right,
Okay.
so what's the date?
Not 6 months, we March.
Yeah, not 6 months,
Yeah,
right?
March is fine.
Mid-March.
Okay. Would you like a date?
Yes.
Date would be good.
15th, sound okay? March 15th?
Sounds good.
March 15th.
Is that okay? Does that work with you guys?
You'll get a notice, of course.
Okay.
Oh, sure, yep, we'll send you
Thank you.
notice.
Good, thank you.
If I may, I'm Steve Wygoda, I'm the architect. I've been working with Rudy's for several years and have been able to obtain their current C of O. We just got a TCO in addition to that, and we've met several times about solving the problem of the noise issue using this roller cover instrument, which I've done several of. I'm also a public member of Community Board 1 in Manhattan, so I'm on both sides of the table, so I know the issue. We are, as of right, approvable for this kind of enclosure. It's counted as floor area. Rudy's has more than adequate floor area. Commercial uses are allowed to cover the entire rear yard up to 23 feet. So I've done all my research. I just want to assure you that with Danny and Jack moving forward, we will file with the Department of Buildings and get all the proper approvals as of right.
Okay.
Thank you.
Great, thanks.
Thank you again.
Take care.
Take care.
209, Lucretia Liz.
You need the acoustics report, right?
Oh, I got it. Here.
Yeah, let me have that too, because
Extra copy.
I don't think anyone got a copy of that.
We're in opposition.
They're in opposition? Is the applicant here? No applicant?
No applicant.
That's easy.
209.
We didn't hear from them, Jackie?
No?
Okay, go ahead.
Morning. Represent Sherman Liquors and Wines.
Our opposition is basically based on two things. Our client received its approval only in October of this year, so it's only been open for a few months. When we appeared on that application, Commissioner Kim noted that there were several other liquor stores within just several blocks in a close area. We were granted it because there had been another liquor store basically on the same block, 2 doors away, which removed to another part of the city. So therefore, we're really replacing that. But therefore, the same issue that Commissioner Kim has, I think, is still there. The new store, this applicant is 900 feet away, literally 2.5 blocks and on the same street, and you can see one store from the other visually. So we believe that it is in much too close a proximity. We believe there is a new, obviously, liquor store within the last 3 months, and that there's no need in the community to have another store at this time.
And is it fair to say your client's Sherman Liquor and Wine?
Correct.
So you can actually see the store from his store?
Yeah.
And you're not even the closest store? Your store is the third closest?
Well, he's on the same block, the other store.
No, I understand that, but you're not even the closest store to this store.
Exact feet-wise, I'm not sure.
Okay.
We're like, not even that.
They're not, according to LAMP.
Okay.
Yeah, I haven't looked at the lamps to see exactly the distance. But yeah, you could, in front of the proposed location, as you look down the street, you could see my sign.
Okay.
All right.
The proposed premises is 520 square feet. The 4 out of the 5 closest have declining sales, with the third closest having just opened in October. We don't have any figures for that. Within 0.4 miles, there are 6 stores that comprise 12,000 square feet of licensed premises. I just don't see the need for another package store at this premises. There's no additional public convenience or advantage provided for by this applicant. There's no mention of any new mix of products, and the applicant isn't here today to answer any other questions that we may have, so I vote to deny.
I vote to deny as well. As the protester pointed out, his client has just been licensed in October. As Commissioner Kim pointed out, there's over 12,000 feet of retail space already within this area, and 6 stores within 0.4 miles of this applicant. And based on the same grounds Commissioner Kim mentioned, I vote to deny as well.
Thank you very much.
Thank you.
207 Bronx Brew.
Do we have the deputy inspector here?
Was that?
I don't believe so.
No?
Sure. What was that?
Is Deputy Inspector McCormick here by any chance? No? Okay. Go ahead, sir.
Good afternoon, Mr. Chairman, Commissioner Kim, Council Flug, CEO O'Brien, Ms. Held. I am Michael Ferrari. I'm here representing the applicant. The applicant is made up of the 2 principals, Aristotle Hatzigeorgiou and John Maggio. Also with me here today are Mrs. Hatzigeorgiou, Anahid Hatzigeorgiou, wife of Aristotle, and John Cullen, who is employed by these 2 gentlemen at another one of their licensees. He directs their security. He will assist in the security at this operation with respect to training and with respect to actually taking part in the security. I'm here to support, to ask the commissioner and the chairman to support this application. We can answer any questions you might have, but I will at the outset point out that the community board has not opposed this application to my knowledge. They have not communicated anything to us, and I haven't seen anything anything with respect to the authority. This is actually the second time that it has gone unopposed. We had sent notice to the community board 2 years previously. For various reasons, economic and otherwise, we didn't proceed with the application at that time, but I would point out there was no to my knowledge, no opposition at that time.
But are you aware of the police opposition?
I'm not aware of it. I heard you asked about the police officer. I wasn't aware that anyone was coming.
Well, the community board reached out to the police department, and the police department refused to approve a recommendation based on past violations, not only at the location, but from the applicants.
I wasn't aware. I'm surprised that they didn't communicate this to me in any way. When was the authority made aware of this?
I don't know when.
This is January 11th.
It wasn't from the police department, it was from the community board. But the community board had emailed the police department.
Right, but isn't there some mechanism by which the authority makes the applicant aware of such opposition?
No.
No, you could ask, and we would give it to you. We wouldn't deny the request, but we don't send it.
You don't affirmatively
I mean, this
send
is
it,
coming
but-
from the community board, and presumably they should have sent it to you, I guess.
Something here from the inspector as well.
I can address it, I can take a look at it, whatever you suggest.
You can take a look at this.
Sure.
This is from the police department regarding the location.
Okay, if you give me one
Yep.
moment to take a look, please.
What year?
I'm not, there's nothing here that I wasn't aware of, the facts, rather, the substance. I wasn't aware that the police department opposed, but none of the substance here is surprising to me. I will, if you would allow me, I would give you a little bit of a history of this building. And Hatzigeorgia was here because she purchased the building in approximately 2009? No, 10 or 11. I'm sorry, 2010 or 11. They purchased it, and the nightclub or the establishment that was there had been there for several years. So they inherited this tenant. To their knowledge, they seemed an acceptable tenant, and they proceeded. They were very much mistaken because as time went on, not only were did this incident happen on February 7th, 2010, but they were a poor tenant. They didn't pay their rent. And so they made every effort to evict them. They brought an action, and they've described to me the facts of it. And it became somewhat ugly in that they did evict them. Through the proper court proceedings. A marshal took them out, and they changed the locks. This tenant came and changed the locks again and essentially broke into property that was not his. Just to give you a sense of who they were dealing with. They wanted them out, and after a long and protracted court battle, they were able to get them out. And the place has been vacant now since they left, which was prior to 2013, correct? It was. I think so, yeah. Right. Their license was revoked. It was set to expire in 2013, but they were out before then. So it has been vacant since then. So certainly more than 2 years have passed since they left. I will speak about these individuals if you're ready to hear from me on that issue, or if you have any questions about the history with the tenant, I can address those.
I'm sorry, the man behind you with the glasses, was he in charge of security at Play? You've been here before.
He was here, right, and it was, Council Fleet was here.
I recall the problems at Play very
right,
well.
It was, but I would point out.
Many of them.
There were many problems, and there were, we had a hearing, and there were, I think, 4 or 5 charges were upheld. You can obviously correct me.
The last penalty was for $7,000.
For $7,000, right.
What's the name of the venue?
And I would.
It's Play, it's in Elmhurst on Queens Boulevard.
Right, and can you remind me of the year, because I think that's important, the year that took place.
Who owns Play?
This is owned by these two gentlemen, Mr. Hatzigeorgia and Mr. Maglio, as well as, there's 2 other owners, one other owner.
The disposition was in 2014. The incidences took place in 2011, 12, 13.
Okay, so I did want to point out that there were no incidents past 2013, and this gentleman, Mr. Cullen, was here because they had recently hired him not too long before that. And he was
That's
brought in.
why I
he was-
remember him.
Right, and he's a memorable person, certainly.
Yes, he was.
For a variety of reasons, but he was brought in because of his talent, and he was able to turn things around. I would say you have not heard from Global,
Correct.
from Play
We
since then.
have 5 principals on the record here for Play.
What are the names in addition to, besides Hatzigiorgio?
Alexandra Giuliano, Francis Maglio, Thane
Gevas.
Gevas, G-E-V-A-S.
None, yeah. I'm sorry, I didn't.
No, I understand who you two are, but you said there was only one other principal and there's 3 others. On
That was, I misspoke, I didn't.
No, you didn't misspoke. They said there was only one other principal.
Who owns the bar?
I'm just asking who owns the bar. That's
So there's 4 of you all total?
There's 5 though
There's
on the
5.
list. Who's Thane Geva?
Van Gervais, he was here the last time, he was here.
And so he's not, he doesn't own Play, or he does own?
He does. He currently, he did then, he does now, and, you know, he has no involvement in why we're here today.
Well, the problem is we have to look at that because
This is all listed, every license
There's a
that they
history.
have.
No, I understand that. I want to clarify to the
Including the
extent I can.
Pantheon Group, Mr. Gavas is also partners with Mr. Maglio and,
Correct.
right?
Right, just he is not involved in, I would really.
I don't
he's not
know,
involved.
you hit his involvement in this one, I'm wondering whether if he's involved in this current one and you're
I'm
not
sorry,
revealing.
in what way did I hide his involvement?
You just told me there was one other person involved who was owner of this, and we just named you 3 other people, so
When I-
2 other people. So isn't that hiding from me?
When I said that, I said I, in my mind, had Mr. Gervais, because I know him and I've dealt with him on many occasions. I personally wasn't aware that there were additional people.
And then there's the mess of Philippe that was.
We can discuss that. I think that's, I mean, Mr. Hatzigiorgio's involvement in that was very, I mean, the ownership was small.
Mr. Farr, if you were sitting where I was sitting and I asked you a question, how many people are involved in this business, and you turn to your principals and they tell me 1 other person, and then you say to me 1 other person, you don't think that's hiding something from me that's not a fact?
I apologize.
No, I'm just saying that you make it sound like, what have you been hiding? I mean, if you make a mistake, then you can acknowledge the error, but if you're going to challenge me and make it seem like I'm accusing you of something that you had nothing to do with, then that's, I think, very incorrect in this particular matter. Am I right?
I think you're right to an extent. I would say.
To an extent, what's the extent that I'm right and what's the extent that I'm wrong?
My knowledge of this, I have dealt with these gentlemen, and I have only dealt with Telly and John and Mr. Gervais in the past. I know that there are other people involved, and I apologize. I don't have the ownership in front of me. There may be an operating agreement we could look closely at, but the reality is that the day-to-day reality is that these gentlemen are the ones that are.
Mr. Farr, you've been here enough to know when we ask for the principles of the day-to-day versus the principles is a very different matter. It was a very simple question. It just brings to the credibility of everything that's coming out of your mouth after that statement to me. So that's all I'm telling you is you can keep going, but now your credibility is in question because of that.
I apologize.
It's not an apology. It's just, I'm just telling you your credibility is in question after the statement you made.
So the problems at Play, I'm sorry, I forgot your name.
I'm John Collins, how you doing?
And, good.
afternoon.
And you weren't there for those?
No.
You came on after that?
Came on after, sir.
And he's running this place too, or helping you run this place too?
Sir.
Where else have you worked?
Well, I'm prior law enforcement, corrections. I'm currently working in Queens General Hospital.
No, I mean as far as any other establishments or?
As far as clubs, yes. I worked throughout the city. I worked Queens. I worked a few strip clubs as well. But I brought the same talent, cleaned it up, got rid of the questionables, and so far had 0 interacting with the police as far as the law enforcement as well.
You got any questions?
Well, no, I mean, there's a history with the Pantheon group as well.
Can I address to an extent, in general, the history? I will answer any specifics about the history. But in general, Mr. Hatzigeorgiou and Mr. Maglio have been licensed in excess of 10 times. Since the last time the two of them were here, Mr. Hatzigeorgiou has been licensed. To the extent that there have been problems, they're relative to the number of licensees, the number of nights that people are coming into all of those licensees. There have been, I would argue that they are minimal and they are in the past.
That's a ridiculous argument, Mr. Fari. If somebody owns 1,000 licenses and then they have 20 serious violations, but then you're using a proportional argument saying because they have 1,000 and they only have 20 serious violations, percentage-wise, they're doing a great job. That is a ridiculous argument for today.
I would point out that I don't believe it's ridiculous. I think you can take into account, you do take into account the number, but I would also point into account the number of years that have passed for each of them. Specifically at Play, it's been 3 years or coming up on 3 years since the last incident, and some of those incidents of that violation went back several years, and we have taken steps to improve on the situation, so much so that you have not heard from Play a single incident. Pantheon Group, the violations that you're talking about go back even further. I only point out the number of places because I want to point out that they understand what is required of a licensee. And for 3 years, there has been nothing, not one problem.
So let me, what's the name of the place, the Pantheon Group? What's the name of the doing DBA is?
That closed about 10 years ago.
Oh, it's closed, okay. And
It was surrendered in 2010.
5 years ago, okay. And the Queens is Play, is that a club?
Yes.
So
It's Chairman, Mr. Chairman, it's a billiards, bowling, foosball, and nightlife establishment.
I don't know if it's clear, that's global and.
Right, no, yeah, that's clear. So this is not going to be that, correct? This is a restaurant?
This is, Mr. Chairman, yes, it's, we're doing a similar version of a place that we have downtown at 90 Washington called Clinton Hall. It's a burger and craft beer venue.
I believe it's smaller than Clinton Hall, correct?
And does that place have, when did you open that place?
About a year ago.
Which was Clinton Hall?
Yes.
To be clear, Clinton Hall, he purchased Clinton Hall from an existing owner. And since then, it's about a year, to my knowledge, there's been no violation, certainly no charges, but I don't believe there's been any investigation.
Is that, what's that listed under here? What's that one, Kerry?
Clinton Hall Holdings?
Clinton Hill Holdings?
Clinton Hall, H-A-L-L.
We have a typo in our, it says Clinton Hall Hill.
I don't even see it. Where do you see it?
Or do this one here.
Oh, okay. And there's no history, at least since you've owned it?
Certainly not. And I would point out that the application for this place is similar to Clinton Hall, but it's on a smaller scale. They'll be doing a similar operation as far as the menu and as far as the beverage menu, but much smaller, much easier to manage and operate.
I mean, look, if you look at the history of the licenses, anything that Mr. Aristotle, how do you pronounce your last name, sir?
Hatzigeorgiou.
Hatzigeorgiou, you've had when you do things on your own, it seems like you have a stellar record. And then when you team up with Mr. Maglio and Mr. Gervais, that's when it seems like we end up with a series of violations.
But, Commissioner, my understanding is that the authority does take into account the number of years that passed. I understand that it's not 10 years that have passed, but it is coming up on 3 years since a single violation was at play.
But I don't think that's my question. My question was, I'm actually commending Mr. Hatzigeorgiou about his stellar record. I'm just wondering what happens when you team up with Mr. Gervais and Mr. Maglio, why is it that you have a history at Pantheon Group and then also at Play with all of these violations that come in? It seems very not consistent with your stellar record.
Mr. Judas is absolutely not involved in this, and we're in the process of trying. He hasn't been at Play in about a year. Yeah. About a year. He's not in, nothing to do with the operations, and we're in the process of negotiating an exit strategy for him.
So are you saying that Mr. Javas is really the person who's been operating these two when you get all these violations? And it's not you, Mr. Maglio? You don't have anything involved with this?
Currently, yeah, I'm active at Play, and I had a lot to do with bringing in John Collins to help clean up Play. And I was here for a hearing at SLA with Michael and John a couple of years ago, which went very well, and it's been very good since then.
Okay.
I think it went well in the sense that we were able to explain what we were going to do going forward. I mean, that we had nothing good to say about going backwards at that point. I think now we have a lot of good to say about going backwards, at least to 2013.
And you have, I'm reading, so P15 LLC, what's that? He can.
That's, it's.
Well, let him tell it. It's under his name. Let him
yes.
tell me.
Okay, it's Philippe.
Philippe Chow, or is that the one?
P15? No, LLC?
That could be what it is.
I'm sorry.
No, there's a Philippe NYC 1 LLC and Merchants Hospitality.
Right, I'm no longer a partner in those venues.
We're
that one you're no longer
negotiating a.
Oh, so P15, you're no longer a partner?
That's the same thing also? Oh, okay.
And what about Superspace?
Yes, that's the location down at the South Street Seaport at Howard Hughes is my landlord.
And what is that? That's
a craft, a similar venue. It's called Ambrose Beer and Lobster. It's a craft beer and lobster venue.
And then Billiards Balls Management, what's that?
That's a location at 54 West 21st Street called Slate.
Oh, okay. Oh, Slate, okay. And 2756 Broadway LLC?
It's West End.
Oh.
West End Hall. That's on 106th and Broadway. That's also a super craft beer venue, similar to what we'd like to do at in the Bronx.
And the Perea Group?
I'm no longer involved.
You're no longer involved? And the Water Taxi Beach South Street?
That's closed.
Yeah,
that's closed.
The Seaport, and that's.
Oh, right. Okay. So 1, 2, 3, and then BHP LLC, Maxwell Chloe.
That is closing as we speak.
So then your active ones are Superspace, Billboard, Balls Management, and 2756 Broadway. Is that about right? And the Clinton Hall.
And Superspace, which is Ambrose.
Superspace, 4.
And Philippe until we fully negotiate.
And Philippe until you negotiate out. Okay.
But his involvement is nothing as far as operation.
All right. Anything else?
No.
So, looking at the email from Deputy Inspector McCormick, he opposes this premise because of the history of what's gone on here before when Ziggy's Stardust Sports Cafe was there. The community board has taken a neutral stance, and this is a 500-foot hearing. Given that they've taken a neutral stance, we don't have any recommendation either way from the community board here. The representation today is that the method of operation will be very different from what was existing here previously. Given Mr., and sorry if I pronounce this wrong again, Hatzi Georgiou, stellar record, and then Mr. Maglio being forthcoming with having cleaned up Play and the involvement of, I'm sorry, what was your name, sir?
John Collins.
John Collins? Collins with an S? Collins. And Mr. Collins' involvement since 2013, there being no adverse history, I will vote to approve.
I'll vote to approve as well. clearly have a number of licenses, as your attorney pointed out, that are, while you do have some negative history at a couple of establishments, and serious negative history, it is several years ago, and it's apparent that at the one place that did have the negative history, there hasn't been any in over 3 years, and I expect that to continue, given the fact that the representations were made that the person that cleaned it up is going to continue to work for you, which is Mr. Cullen, because based on his appearance, it appears he could handle any situation that might come upon you. So I'll vote to approve as well. The only thing I am going to ask, because it's clear that the police department is concerned about the location, given the last business that was there, is that you sit down and speak with someone from that precinct and meet with them to at least ease their concerns about what you're going to do. I don't want to see that this is going to be a club. I don't believe it's going to be, but if you guys end up here in front of us again and it is a club, then you're going to get a really short leash. So.
And I would just add, please meet with Deputy Inspector McCormick, or at least make every attempt to do so, as someone from the precinct to meet.
Yeah, definitely contact him. If he can't meet with you, then ask him who you should meet with. But I vote to approve.
Okay, good luck.
Thank you. Have a good day.
212, 784 Cafe.
Hi, good afternoon. Hello, good afternoon.
Good afternoon.
I'm Patrick Sterling. I'm a manager of our 784 Cafe. John Foley is proprietor. I believe the hearing is to discuss whether the adjournment that was requested by our attorney on the hearing apparently never occurred. So apparently there was a hearing without our representation. So I gather today is to determine whether we're going to get a hearing in the future to review this matter. I believe there's a $4,000 fee out there, but the request is to have that in abeyance and hopefully get the new hearing so we can get representation.
Your attorney just
He's in a criminal
said
matter.
he was otherwise engaged.
Yes,
Excuse me?
He's a criminal matter, I believe, that he could not.
We're going to take 2 minutes.
Sure. Okay.
All right, so what we have is that your attorney sent in a letter asking for an adjournment from the hearing, a date that he was notified was going to happen, and he sent the letter in about 2 or 3 weeks, or 2 weeks prior to the hearing date, and he just said he's otherwise engaged without giving us any specifics about why he couldn't make the hearing, and then never contacted us again. The policies we have here require that you give the specific reason that you can't go forward with the hearing, and you'll more than likely get granted the adjournment. He didn't do that here, which is why the hearing went on without him and you. Because it was 2 weeks in advance, and I, in my belief, think someone should have gotten back to your attorney and asked for more information, I am going to send this back to counsel's office, provided Commissioner Kim agrees with me.
I agree.
And you will get another hearing, but I would if you are going to get a lawyer, I would make sure that the lawyer stays in close contact with our agency, particularly if he's going to ask for any adjournment.
I will so advise. Thank you.
Okay, thank you.
Is there a date set now?
We'll be notified.
Thank you so much. Good afternoon.
167 and 168, K and Kmart.
Good morning, Mr. Chairman, Commissioner, Deputy Commissioner, Secretary, Counsel. Jonathan Schloss of the law firm Schloss & Schloss PLLC for K&K Mart, Inc. I have with me here today the two individuals who are on that license, Mr. Kawar Saeed and Salman Kushnud.
So case 167, you have an offer of $3,000?
We've been offered $3,000 with the proviso that if they enrolled in the ATAP-approved course, that fine may be reduced.
Aren't you also asking for a 15-day suspension instead of the $3,000?
Yes, well, on the second charge, but it could be applied to either one, really. But yes, my client would agree to a voluntary suspension in exchange for a reduction in fines.
But for both cases, you're looking for $6,500 and a 15-day suspension?
What was put forth in the letter was $2,250 on the first charge, provided that they go through the ATAP-approved course.
That's automatic. That's automatic, so.
Right. Which they have.
That doesn't happen here, that happens on the back side.
Yeah.
I'm sorry.
The discount you gets, if we say $3,000,
Yes.
it ends up being $2,250 because you took the course. That's what you're required to pay.
Okay. And on the second, we took a conditional contest plea of $6,500, and that's what we're asking for a 15-day suspension in exchange for a reduction in the fine.
Okay.
So for the first one, I'll accept your $3,000.
As will I.
For the second one with the 18 and under charge, are you okay with the 15-day with maybe a...
If I may talk to that incident for a moment, Mr. Commissioner.
Go ahead.
Mr. Salman Kushnan, who's one of the principals here, was training the individual who was selling, who actually sold the product to an underage person. Mohammed Saeed, who's got no relation to Principal Kawar Saeed, except for just the last name, relatively young, in his 20s, and was in training, and he was just in the restroom and wasn't supervising him at the time. He has since undergone a program that's run by the Clarkstown Police Department called the Safe Management of Alcohol Retail Tobacco Sales Program. We're trying to verify with the authority whether or not that's an approved ATAP course. We're told that it is, but I didn't see it on the website, and we'll look into that. But he did take the course shortly after, and this has been a source of worry for them as well. Certainly regrettable incidents. They take it very seriously. We told them as well how serious this is, and they're respectfully requesting the suspension for 15 days. And
so 15 days with no fine or 15 days with minimal fine? Reduction in fine, 15. What do you think, 15 and...
Generally, it's calculated as $100 per day.
Oh, it is? So 1,500 and then 5,000?
Right.
1,500 and then 5,000?
I'm told anecdotally.
When were you notified of the first sale? When were your clients notified of the July sale? Do you know, approximately?
When were they notified of the sale?
When were they notified by was that a police department sale that they came in and told them immediately, or we didn't do that?
It was immediate.
It was immediate?
Yeah, it was immediate.
Okay, so go ahead. I thought that would affect the fine, but.
They got one on September 10th, a notice of pleading, and then the second one they got October 20th.
The notice of pleading from the authority was...
No, I'm more worried about when they had actual notice that they did this, which was before then.
When it happened.
Before the second sale.
Which would affect the way you would...
Right.
So they knew that, and it's...
I was going to give them the benefit of the doubt, but they're not,
Well, I
you
mean,
can't give them any.
It's just that it was a relatively inexperienced person up front. at the time.
Given the location, 15 and 4,000?
Okay.
15-day and 4,000, is that acceptable?
If it's,
Or would you just rather do the 6,500? No, I'm giving you a choice, really.
no, it's acceptable. Actually, may I have 20 seconds?
Sure.
Yes, it's acceptable.
I'll take that too then.
All right.
15 days and 4,000. Thank you.
Okay.
You'll get notified of the suspension, correct?
Yes, we'll send out
Also,
notifications.
regarding the time within which to submit paperwork about the coursework.
Yep, you'll receive notification, if you exceed the date, if they pay the full fine, and then we get the paperwork, we'll issue a refund.
And just be aware, the third charge is usually 10,000, so, and the fourth, you lose your license. Just letting you know what to watch out for.
They've been so advised. Thank you.
Item 220, a request for declaratory ruling for property located at 75 Essex Street.
Hi, good morning. I'm Elke Hoffman, attorney for ADF Group. This is a request for declaratory ruling. This is really a case in which the client doesn't want to put the cart before the horse. The project is a very large scale, involves a purchase of a building. We're in multi-millions of dollars. The school that is the main entrance is at $350,000. Is a large high school. It was one high school. Now it is a series of, it has been broken up into a group of 5 high schools. A gym that is rented out for public access. The rooftop, which is being renovated, has been used for rooftop films. And the playground is now administered by New York City Parks. So, the question my client has is whether the 200-foot rule would prohibit a full OP within 200 feet, given sort of the breakdown and again, the investment that they're looking at is something like, $30 million. And so this is in advance of any community board. This is really just trying to see whether this is even a feasible location for the kind of project that they have in mind, given the additional uses now of what was one high school.
Do you have any questions? I mean, the way I see it is that the activities that are occurring currently are, in my opinion, incidental to the operation of the school, and based on precedent where ABCL, and also the statute, ABCL Section 64-7D1, provides that place of worship does not cease to be exclusively a place of worship if it even allows non-congregant members of the community for private social functions. I liken the activities that are occurring here, the New York City parks allowing for children to use the parks during non-school hours, the rental of a swimming pool for predominantly a children's swimming program, and then the rental of rooftop to show films, and I do see the argument that some of the films that were shown are not appropriate for high school kids.
But that one is definitely not incidental.
Well, I think it's how we look at it in terms of it's being used for a purpose to raise funds without giving up control of the
But that's no different
Of
than
the
the
premise.
theater groups and churches, which also then you have plenty of declaratory rulings where, a theater group using part of a church has taken that out of the 200-foot rule as well, so.
I think those vary, and those are long-term projects that the churches have taken on, as opposed to, this is a New York City high school that has always been a New York City high school and is going to continue to be a New York City high school. And especially the playground issue. I and many other parents take their children to the schools on weekends to use the playgrounds and never stop considering it a school. We're grateful that the gates are open on the weekend, and I don't think one use of a movie for additional funds changes that place being exclusively used as a school.
It was a series all summer long,
Yeah, well, and that's part of the thing that I see most problematic with trying to say that this shouldn't be seen as just a school is that every activity that you've listed, and as Commissioner Kim pointed out, 2 of them at least involve children, is when school's not in session, whether it be after school or in the summer. So I really think those activities are incidental to it being a school. As a result, I mean, the case that's out there is talking, that said they weren't incidental, is talking about a dental clinic, a medical clinic that's also operating at the school, a vocational workshop, an adult rehabilitation center, all at the same school. Whereas here, we just really, the only viable activity you're talking about is showing a few movies at a museum that the school does use, but they don't use for particular movies, and when those movies are showed,
It's a for-profit.
school's not in session. So I don't see that, I still think the 200-foot law would apply here.
And I think the not school in session is really the key, because I know years ago, we used to, as a group, rent out gyms throughout New York City's public schools, and we used to go play basketball on evenings and weekends and be paying money to the school for them to raise funds. And it wasn't, we couldn't rent it during the time school was in session, obviously, and I think that's kind of where the differentiation would come in a church where they're renting apartments, for example, where people are living there, whether the service is going on or not, takes it out of the exclusive church zone. But in this particular case, the activities that are going on after school, incidental to the school's functions normally, and trying to raise funds for the public schools, I think doesn't quite get it out of the exclusivity space, in my opinion.
This is why they want to know in advance.
I can understand that.
That's the right thing to do.
So, sorry.
Yeah, sorry.
Thank you.
192, 502 Bar Restaurant Corp.
Good afternoon. My name is John Angrasani. I'm here for Ms. Valerio to interpret for her. She's my sister-in-law. She made an application to extend her hours. You gave her a license back in August and allowed her to be open until 2 during Sunday to Thursday and 4 a.m. on Fridays and Saturdays. Since then, the business has been going well. She's been doing okay, and she's looking to open up those extra hours during the week. They're on Jamaica Avenue, a busy establishment. A block away from her are two big recycling facilities and one waste service, also a moving and shipping service that's open 24 hours. And it looks like there's a demand from certain people, if they could stay open a little bit longer, allow them to make a little bit more money. And she's had no incidents since the license was given. The police were there. ¿Cuántas veces fueron los policías? One time, they reviewed everything with her. Everything was okay. They did not have any concerns. I believe the community board also was not.
The police were there to respond to a call, or police were there to just talk to her?
Just to check.
Okay. We approved it in August of this year, so it's been 4 months, 5 months. Normally, we'd like to see a little bit more of a history, usually sometimes 6 months, but usually a year. That's my only real concern. I'm glad that there's been no adverse history. Do we have anything pending here?
No.
So
I will double check right now again before I say that.
we haven't had any complaints that we know of. So how close is this to residential areas? It's on Jamaica Avenue, right? Are there any? This
The
is all
entire thing is commercial, I believe.
commercial strip? Oh, yeah. So there's no houses there. Yeah. No houses above or anything? Apartments? Except her?
She lives upstairs, yeah.
Except her, but nobody else?
Nobody else.
It's been 5 months. I'd be open to it, but ideally I'd like to wait a year, but.
Whatever you want.
It's no help.
No, I mean, I had, I agree with Commissioner Kim. We usually wait a year, but you actually coming in telling me that there's 24-hour businesses there, I understand what you're asking for, and it doesn't, it makes sense to me.
They're one block away on Douglas Avenue. And she went to the community board, and the community board, I think, was not opposed at all. I think they stamped her form. And
So you're talking about shift workers coming off their shift.
Correct.
Who want a drink and can't get it.
Correct.
All right, I'll vote to approve.
I'll vote to approve as well.
All right. Good
Thank you
luck.
very much. Thank you. Have a good afternoon.
191, restaurant, this is going to be, Restaurant y Panderia Cazal. I'm really doing bad on that name, I'm sorry. It's women.
Are you okay with this? No? Yeah?
Yes, I am.
Okay.
The question I have is, I can ask later.
You can ask it.
Hi, good afternoon.
No, not for them, it's for us.
Oh, okay. Hi. Just put your name on the record, please.
Jody Ruddy.
And everybody's.
William Medina.
Adriano Leon Concepcion.
Thank you. What's your question for us now?
Why did this end up here?
It's at Spring Valley.
It's
In
Spring
the
Valley.
delegation of authority, Spring Valley had quite a few incidents of violence with on-premise establishments, and we had a meeting with the police department who had requested that we just take a closer look at every application coming in for on-premise consumption.
Okay. So
I would just like to let you know that I spoke to Detective Hughes back in September, who asked me, just to give a brief history of their other locations in Connecticut, which I did. And I also sent him pictures of those locations showing that they're more family restaurants, no bars. And he approved it. He said he had he wasn't opposing it. And then I just spoke to him weeks ago, and he said to mention his name again, that he's all for it.
Do they have any adverse history in their other premise in Connecticut?
No, they do not.
Absolutely zero?
Yes,
Nothing?
nothing.
How long have they been open in Connecticut? Approximately.
Since 2004, I started working, but I started with a small bakery.
Okay.
And then I have 2 restaurants.
Okay, all right. All right, based on those representations, I'll approve.
I'll approve.
Good luck.
Thank
Great,
you.
thank you so much.
Good afternoon.
208.
208, NLS Entertainment.
This is my question. What Korean taco they said they would have on this menu?
Oh. This one or the last one?
This one. It's coming up. Hi, how are you?
Kenny Prasad, Robert Gomes.
Your
This is-
attorney's not here?
And it's unlike her not to appear.
Is she still working for you?
I elected not to bring her. I didn't think I needed an attorney.
Oh. Well, the issue is that she said the community board approved, but we have a letter that says community board's against it.
Well, what happened was we issued a 30-day notice back in June, and we didn't hear back from the community board. Actually, they just sent us back a form that says we need to fill a new form because it's outdated, the one that we filled out before, and they would give us an approval. We didn't hear back until we went forward with the sale, which was in October 7th. And then the community board voted until November, I think about the 9th or 10th. That's when they disapproved. So had we known they were going to disapprove, we wouldn't have gone forward with the purchase of the business.
And I do want to point out that it appears to me that they misunderstand, at least the letter I'm seeing says that they oppose this license as they are in violation of the 500-foot rule, which really doesn't help us at all, because they're supposed to be giving us an indication of why they're opposed to it, rather than the fact that the 500-foot law applies. We're aware that the 500-foot law applies. It doesn't mean there can't be a license there.
Well, we attended, it's a prior business.
I'm just stating that for the record. That wasn't directed at you.
Well, when we attended the meeting, all they said was, based on the 500-foot rule, we oppose, and that was the voting. That's all they elaborated on. They didn't, specify.
There was an
why.
existing location there, and you purchased the business?
Correct.
Can you just describe what kind of business you're going to run?
It's a restaurant lounge?
So is that a club?
No.
DJ?
No.
No DJ?
You got DJ here.
We were
Sure.
thinking about it at one point, but we're not doing it.
You're not going to do a
Not gonna
DJ?
do DJ, right?
No DJ. Security and everything.
But, you know, we have people who come up here and argue with us later about the definition of a DJ, but we're clear that it's somebody who stands there and coordinates music, right? No DJ?
Not right now,
Okay.
it's too expensive.
Too expensive?
Well, so what your license is going to say no DJ?
Excuse me?
I just wanted to make sure they knew that if they wanted to add it, they'd have to come back.
Yeah, if you want to add it, you can't just say, oh, we'll just try it. It's a different method of operation. And what's this Korean taco? That's my curiosity.
That's something that my brother actually is married to a Korean.
What
What's in it?
What is it?
No, it's like, it has kimchi and everything. So it's like, it's a homemade product that he discovered, so.
Interesting.
Is there meat in it?
Yeah.
There's got to be meat in it.
Oh, they love meat.
All right, well, I mean, it is a 500-foot rule, 500-foot case here, but the community board has opposed it, but based, as the chairman pointed out, solely on the fact that they are in violation of the 500-foot rule, which to me doesn't really make sense in this particular situation. Also, there was a premise here previously, and the method of operation we're talking about will not be a club, it'll be a bar lounge, did you say? But no DJ.
Restaurant lounge.
A restaurant lounge. And what are your hours again?
We've been testing out different hours at the current time, but we noticed a lot of our clients are coming in after 9 o'clock.
So,
Right now it's operating until 4, but. most
4
of the
a.m. every day?
Yeah, but we've been closing between 2, 3 o'clock right now.
Okay.
We get an early crowd and a late crowd because there's a few other places, a club down about 5 or 6 blocks from us, so we get customers going and exiting, they come back to eat because we keep our kitchen open.
You have to. Right?
Well, a lot of places, I think they stop serving about 2 o'clock, so we were open until 4.
All right, and we also had a 200-foot question. Our investigator, Barry Sender, went out, measured the church. It was 154 feet, within 200 feet, but we also then subsequently received an email from the pastor who wrote that the tenants above the church are not affiliated with the church, so the 200-foot law does not apply here. So based on all of that, I vote to approve.
I'll vote to approve as well. As Commissioner Kim pointed out, it's apparent to me that the community board really didn't do a review at all on whether this was in the public interest or not. They just refused to recommend it based on the fact that it was a 500-foot case. We had a 500-foot hearing. At the end of the hearing, the ALJ determined that it was in the public interest, and I agree with him. There was a restaurant there previously that had no negative history with the SLA, and these gentlemen plan on having a restaurant at the same location, so I'll approve.
Good luck.
Thank you.
174 NY Tracks Cafe.
Good afternoon. My name is Lenva Leard. Principal is Werner Leard. I'm here on December 23rd. I plead no contest for the emergency light that was in the basement. That's where only the employees go there, and I fixed that. There was a burned out bulb there. And the security, we have a new contract, and we have all of the guards, their license, and we have a file in the office with all the pictures and copy of it.
And do you have a licensed cabaret now, or do you no longer have dancing?
No, I'm working on it, but for now, no dancing. I have signs everywhere.
All right, I have 4,000.
I was going to give them a break, because
All
it's
right.
clear to me that they went to check for dancing and there wasn't any.
Okay, so how much?
2,500?
All right, 2,500.
Okay, thank you.
Thank you.
221 and 222 Silver Line Lounge.
This is an offer of compromise to resolve the charge.
How are you?
Good, how are you?
Good.
So the license
New
has
Year.
been surrendered, correct?
Yes.
Well, I mean, 7,500, I'm okay. I'll accept.
I'll accept.
225, Sunny O's.
This is here as a result of a hearing. Just want to make a brief comment in mitigation. When the owner was contacted immediately by the police, when the police arrived, they cooperated fully, showed all the video to the police because there really weren't anybody who saw exactly what happened when it happened. So they had full cooperation with the police. The incident was very brief. And I'm not going to dispute what the ALJ determined, but I would ask you to keep those factors in consideration when issuing a penalty, as they did cooperate, and it was an incident that was very brief in time.
I mean, my only issue is that there were two other disorderly premises in October and November of 2014. We had imposed a fine in March 2015, and then in June, we had another incident.
The only thing I would say is the two people involved had some kind of history between them. They were arguing over a phone, which started outside. And as I said, this was very brief.
Why is it that they've had, since 2004, pretty much a clean record, and then only recently we're having all these disorderly premises charges come up?
During that period of time, they were not doing well financially, quite honestly, so they cut back on some of the personnel that they had there. Now, since these incidents came up, they went back to adding a personnel that was there on the weekends because this happened. And basically, they had somebody there more at night, later at night. These things tend to happen later towards that evening hour, where they just couldn't afford it before, but I made it clear to them that they have to have that person there.
All right. I'll do 3,500.
I'll agree, 3,500.
Thank you very much. Have a very nice day.
See you.
144, J&M Wines and Liquors. Okay, Mr. Warmikowski?
No? Can we just, can we still do it, though? Yeah, offer.
The licensee's here?
Licensee? J&L? J&M.
J&M.
Yeah, that's
Is that you?
Thank you.
I know Henry was here this morning.
And, my name is Jose Maldonado.
Okay. The offer of letter of warning for the EBT cards, I'll accept it.
I'll accept. You'll get a letter in the mail.
So you won't accept that anymore, right? That's, yeah, thanks. Thank you. That's it. You just get a letter of warning. You don't have to pay a fine.
I thought it was for the liquor authority,
Okay.
for the license.
You want a license?
No, he may not be for this
Oh,
one.
you're probably not.
What's the name of your company?
JM Express Deli.
Oh,
It's a small place.
So you just accepted a plea for another company. Sit down.
Somebody else.
This isn't for you. No, it's okay. It's very close names.
That's why I don't ever go into court and plead guilty to something. So we can do this anyway, right?
Offer is still for letter of warning. I'll accept.
Accept.
All right, let's get rid of that.
Thank you.
223 and 224, Pat's Palm Tree.
Thank God you asked those questions.
Licensee Timothy Allenwick.
All right.
This is an offer and compromise, 8,500, 5-day suspension. The owner's with me.
So
You have photos of the food
we do.
and security, the insurance policy.
Thank you. Looks good.
The problem is, they were closing the kitchen like at midnight. They didn't have the food available all the time, so now she understands that, she's straightened that out. But they've always had a full menu.
And the security guard, you said there was a contract?
Yeah, there's a contract there.
All right. I mean, we've had no food on 2 or 3 occasions now. So you're saying now she's going to have food anytime the premises is open?
Yes.
I mean, I'll accept 5 days.
I'll accept 8,500, 5-day suspension.
Okay, thank you.
Can I get the food pictures?
You want these?
No, let's put it into evidence.
Thank you.
Give them to you.
Thanks. All right, request to recall item 168, it's K&K Mart. I'll bring the item back.
Oh, it's okay. I think,
Right here.
unless,
The board had taken a 15-day forth-looking 4,000. When they got outside, they misunderstood, so they just wanted the item recalled.
Okay.
all right.
Okay.
So what they misunderstand?
Well, they thought they were accepting a $4,000 and a 15-day suspension to settle all claims.
Oh, I see.
So I just wanted to, if Sharon could perhaps clarify what's being offered, the 2 options, I'd appreciate it.
Well, the one was 3,000 for the first violation, which then gets reduced by your ATAP certificates to 2250. So that's what you'll end up paying on that. The next was 15 days and 4,000 because it's your second offense. Had you not wanted the 15 days, it could be no suspension and 6,500, which is the general fine for the second sale to a minor.
Okay, so
when they're 18 and under.
When they're 18 and under, right.
6,000.
As Commissioner Kim noted, I don't know if he said it to you, but he said it to someone shortly after you. The third sale is 10,000, and the fourth one is loss of your license. That's our general policy. I'm not saying there's never exceptions, but it's very rare.
so it's going to be,
And I think in general, I mean, this is something, Secretary, are you secretary? You're no longer secretary, right?
Acting secretary. Today I'm
no.
acting secretary.
Deputy Commissioner, has told us is, usually, I guess historically, we've calculated $100 per day of suspension, loss of business. And so $1,500 would have been 5,000, but given the circumstances, right? We gave
Yeah,
a
it would have
further
dropped to 15 days plus 5,000. They dropped it a further 1,000.
I dropped it, we dropped it another 1,000, but I don't know if what is,
well, they one of the things they were saying was, well, could we do 5 days and 4,000? I said,
well, based on that calculation, then the money would go up.
Yeah, it would go up.
It's like this, right? Money and suspension,
understood.
so.
I believe that
I understand. It doesn't hurt to try, but
Yeah.
I think we're stuck where we're at.
yeah, because I think I mentioned to you, we gave a further.
We already gave a $1,000 discount.
I understand. So they're willing to accept
Okay.
the 6,500 and no suspension.
Oh, okay.
Okay.
All right. That's fine too.
So they're selling more than $100 a day.
They did the.
We got to redo our math. Yeah, that's acceptable, 6,500.
Thank you for reconsidering.
Thank you. 226C, JM Express Deli.
Yeah, how long is that calculation from? Is that? No,
Well,
I'm just saying. if
Yeah, a
they're calculating
long
that.
time ago,
Yeah.
a long time ago.
All right, here we go. What was that number again?
226C.
226C.
This matter was carried over at the last board meeting. However, Secretary's office received an email, which we didn't attach. What you did receive was a police referral that they had a violation while operating under the temporary. When they applied for the extension on the temporary permit, we denied based on, the violation and also the fact that it was coming to the board this week.
right, so what are your hours?
There's another violation?
No, it's the one you see in there.
Okay.
There is that one you see in there.
Okay.
Yeah. What are your hours?
That's why I brought it up.
Weekdays says from 11 to 8 o'clock. And the weekends I stay to 10.
To 10 p.m.?
Yeah.
8 p.m. on weekdays, 10 p.m. on weekends? And what's the charges? Sale to minor.
Which we can charge forward to.
Where's that? I don't see it. Where is that? There's another?
I have the.
Oh, it's in the system?
It's the one sale to minor.
Oh, this thing over here. Okay, okay. Police referral.
If the license is granted, we'll then prosecute.
So what happened,
This was
what happened with
temporary.
the sale?
It was the day there was another person, was training, and I stepped out, and it was an accident that time.
Who's Jocelyn Maldonado?
Jocelyn is my daughter.
She's the one who sold?
Yes.
How old is she?
26.
She understand now?
Yes.
Okay. So what do we do to?
What are we doing here?
You can approve and then.
Well, if you issue the license, we'll then prosecute the charge. If you do not issue the license, we will not do anything.
So what,
Anything from the mayor?
there's no history here, right?
This happens, this happens.
No, I mean with this individual.
Um,
You've never had a license before, right?
No. The first
And what's can I make him do ATAP?
You can make that a condition of the license, anything.
Okay. Okay.
Is your daughter going to be there regularly?
Only when I'm not there, so it's like part-time in the morning.
But you're 34 years old, and
No.
you said, no, we have here Jose Maldonado. That's you?
I'm 43.
Oh, they reversed this, okay. Oops. We have 34 years old, and then you said your daughter was 26. I'm like, it could happen.
You're doing the math.
No, it could be it could be a stepdaughter or whatever. It's
71.
It's all good. I just wanted to, but 43. Okay, so I'll vote to approve based on these hours, and then we can impose a fine today?
No.
No, we have to issue a notice of pleading.
Okay.
So you'll understand we'll be prosecuting you for the sale to minor, and the average penalty to that is about $3,000.
ATAP.
Okay.
Yeah.
So you'll get a notice from us with charges for that you'll then have to respond to.
Okay.
You're gonna have to come back, is what she's saying.
Okay.
So what I'm gonna do, are you sure you're only 8 p.m. to 10 p.m.? I mean, 8 p.m. during the week and 10 p.m. at night? Because that's all we're gonna give you.
What days? You have Monday through Friday, 11 to 8 p.m. Is that correct?
Yeah, 8, not later than 9 o'clock. It's
All
like
right, so
never,
you should be clear. But Fridays, you're probably going to be open a little later, no?
Yeah, like 10 o'clock.
10
Sometimes
o'clock, right?
it's-
So Monday through Thursday, 11 to 9 o'clock,
Yeah.
and then
It's about the same time every day.
and then Friday, Saturday, Sunday, you can be open till 10 o'clock.
Yeah.
Yeah. Okay.
And you know, if you're gonna stay open later, you have to come and ask
Yeah.
us, because
Okay.
you're violating your license if you do. That's why we're making sure you know what the hours are.
Yes.
So I'm going to grant the license as well, and I'm going to require that you and whoever works at your store take ATAP. It's an alcohol training awareness class,
Yes.
so that you don't sell to underage people anymore.
Right.
So that'll be in the letter. You can find out how to, where does he find out how to take one of those?
On our website.
Yeah, it's on our website.
It's on our website, so you're going to have to take one of those classes, and usually you can find a place where they'll be free. So, usually, right?
No. No, John, there's online classes too.
Oh, there's online
Online
classes, so you're going to have to pay
classes.
for it. I don't know how much it costs, but it's not ridiculously expensive.
Okay.
And then you're going to have to come back here and do that, and take care of that charge.
But the benefit is that you'll learn how not to sell, and then if for some reason an error does happen, you also get a discount.
Well, the error did happen, so
Did
you'll
happen,
get
so
a
you'll get a discount.
discount off your fine on this case.
Yeah. You'll get 25% off the 3,000.
So the course will pay for itself.
Right.
Okay.
Do you understand?
Yes.
Okay. So I approve on those conditions. If you have any questions, call the agency. Just don't ask for me.
Okay.
All right.
Good luck.
Thank you.
Thank you.
Ready to go?
Yeah.
All right.
Can we take 2 minutes, just because I...
Okay.
Actually, I'm going to use the restroom myself.
Hey, Joseph, who are those? Were there other people sitting here?
Oh, they were just observing, and they're applying for a license, I guess.
Oh, so they're just studying? Oh, so,
It's not like we have tapes, you can't
yeah,
watch
you
film.
could just watch it from home. About, with Margarita offering 2,500.
Okay, we're going to start the remaining items with 133.
Okay, offer of 2,500, accept.
Accept.
134.
$100.
$100.
135.
Excuse me?
That's not the, usually $100 is for the pregnancy sign.
Oh, this is the license is
Yeah, this isn't-
250?
Yeah, this is,
Is that two? No, 250 though, right?
It's a recall, whatever that was.
Sorry, recall.
134.
Thank you
and
for
that'll
that.
be a $250 fine.
Yes.
135.
I mean, this one, we never got the disposition of the felony. He was carrying a kilo of
Yeah, I
cocaine.
don't know that that matters to me.
At this point, what are you, all right, so
That's about 30,000 of cocaine.
And it was a default.
So I'm canceling bond.
cancel bond.
136,
And based on that calculation, 1950?
What'd you say?
1950.
1950, you're going to accept the lights, no contest plea? Or treat it, keep it as a default?
We can accept it.
That's not, it's just, yeah, okay.
We'll keep it as a default and impose the,
You want to keep it as a default?
Either way, it doesn't,
yeah.
Okay.
your penalty's the same.
They may not like to be defaulted. 137,
Offer cancel and bond, accept.
Accept.
138,
I have 2,000, because it was a second extension of premise.
I have actually 3,000 for that same reason.
Okay, 3,000.
He just doesn't get it.
Yeah, it's the second.
139,
Cancel for the record.
Cancel.
sorry, 141,
Offer 6,500, accept.
Accept.
142,
Just, we have availing? Why don't we have an availing charge here? I know, but this is where his brother was, when that owner's not on the LLC record. So he said he was the owner, but he's not
We
one of
would
the
need
two
a
recorded
further
LLC.
investigation for
Yeah, so
that.
further investigation, but on this charge, 2,500.
2,500.
143,
Offer of 1,200, accept, dismiss, charge 1. Council request charge number 1 to be drawn.
It's actually an offer of 1,200.
okay, 1,200,
Accept.
So offer of 1,200, I'll accept and dismiss charge 1.
okay. 145,
Offer 1,500, accept.
Accept.
146,
For 2,500,
This
accept.
was the wine to go situation that we had talked about at places in Midtown.
Yeah, the liquor, I've actually talked to the liquor stores about this. I'm going to
Right.
counter with 3,500.
Is that what we're gonna do
Okay,
for?
the last time you counted with a 5.
Oh, then
5,000?
5.
Yeah.
Okay, 5,000 then. That's what we're setting now when these liquor stores are,
There are Ws or, yes, usually RWs that are like salad bar places selling.
Where this was an instance where there was absolutely no intention, and it was clear that the person had no intention of drinking the wine on the premises.
Correct.
They just opened it and walked out with it.
all right, so the precedent will be 5,000, first
Yes.
offense,
5,000.
wine to go.
Fine to go.
147,
Just offer 7 days deferred suspension plus 1,500, accept.
What is a deferred suspension?
it's a suspension that's held in abeyance for 12 months. 12 months.
How many months?
12 months. If the licensee has any other violations that are adjudicated within the 12-month period, the members can add the 7 days on to whatever the new penalty is.
Well, they first have to be adjudicated to be guilty of the new offense.
never-
It's something that,
It was a very old policy but when the board didn't, wasn't imposing a fair amount of forthwith suspensions. It was another means of deterrent.
But it's not, we can't litigate a case in 12 months, most likely.
Well,
But
back then they
They go to
did.
hearing.
we use this now more with large companies of wholesalers when deferred suspensions really are issues of credit and other things that are meaningful. I don't think they're meaningful. I don't think you need it here. I think the 1,500.
Yeah, this is an old TL license. Old TL and RL licenses were issued back in the 70s. If they had a prior history, like back in the 80s, then deferred suspensions was very common.
Yeah, I think the 1,500 alone is
1,500 is enough?
sufficient.
Yes, I'll do that, 1,500, counter 1,500, or
But
whatever
we
you
still
do.
do
It's
the
15.
deferred. I'm sorry, I was just going to say, we still do the deferred on the wholesale cases at times.
148,
Offer 10,000, accept.
Accept.
149,
Offer 5,000, accept. Wait, what are this? Shows up on alcohol party on roof.
Restaurant
Oh,
uses
yeah,
room
no-
for private special events without permit.
Yeah.
I thought that was kind of low for setting up a bar on a rooftop in
No,
Soho.
and I have my notes here when I'm looking at it again. So Jaworski Investigator Jaworski went in on 7/8, talked to them and said, you can't do alcohol. NYPD Vice shows up on 7/11 and they're having an alcohol party on the roof. The only explanation is that they're probably, isn't this a hotel?
I don't think it's a hotel. I've been on the website. It is a very corporate, well-run.
Well, no, but it's right
violations.
next to 60 Thompson. and
Yes.
So they might have already booked it in advance and they probably felt like we could get away with it.
Elke Hoffman was here today. They have no other violations and have been good operators beside that, but I did think it was a lot of,
It is,
to put a bar up on your roof in Soho.
So what do you want to do?
Given these set of circumstances, counter with at least 7,500 if not.
Okay. Counter 7,500.
Got it. 150 and 151.
Offer cancel and bond, accept.
Accept.
152.
Offer 1,000, accept.
Accept.
153.
Offer 1,500, accept. Is that 6 months, right?
Yeah. 1,500 and, what's this? Oh, right, 1,500, correct.
154.
This is 5.5 months. Offer 1,500, accept.
It's 1,500.
155.
Cancel and bond, accept.
Accept.
156.
Offer 6,000, accept.
Accept.
157.
Yeah, this one was sketchy. They took him off the license in case so he'll get unemployment insurance, but then
he
never applied for it, so then he's back on it again.
And he shared the profits.
I personally don't support the 6,000. I know we've done it on some availing, that it's become a pattern on some availing matters, but others where people change the corporation, we're canceling the license and making them apply for a new license.
Yeah.
They did file a corporate change application. It was denied for $589.
Should bring him in? Or?
If you want. Yeah, bring them in.
Yeah, let's hear.
To find out what's
story,
going on.
yeah.
Over 2-2.
Okay.
158.
Cancel and bond. License.
Can we bond?
Yeah, why not?
Surrendered.
Because it was surrendered already.
Fine, I got 2 years after the bond expires.
Okay, so cancel and bond.
Yep. 159.
Dismiss charge 1.
Dismiss charge 1.
You throw me off there, that's the only charge. 160.
Can I ask for a letter of warning here because they didn't sell to the minors? We have frequently found
That's what I had.
cases.
Letter of
Yes,
warning.
letter of warning.
161.
Offer 7,500, accept.
Accept.
172.
He's dismissing 2 here, right?
Yes.
Failure to supervise.
Yes.
And then
Dismiss
offer
charge
3,000, accept.
Accept.
173.
Offer 3,500, accept.
Accept.
134.
Sustain
I'm
1.
sorry, 164.
Yeah, sustain charges 1, 2, 3. Dismiss 4, 8,500. Offer, accept.
Accept. And dismiss the charge.
165.
Offer 3,500, accept.
Accept.
166.
3,000, accept.
Accept.
169.
Offer 500, accept.
Accept.
170.
Offer 1,000, civil penalty. License was surrendered, or accept. So we don't need to cancel it, right?
No.
It's already, yeah.
They don't pay, I take the bond.
So we get 1,000. Okay, yeah, I'll accept.
171.
2,500,
2,500.
172.
5,000.
5,000.
173.
Okay, this one,
Yeah.
Henry Street.
This was in relation to Henry Street, and Mr. Parisi chose to put in a no contest. Our offer to him was $20,000 with a 30-day suspension. I think you may want them here
Okay, bring them in,
for you
2-2.
impose. Up to you.
I mean, I don't need them here.
So what do we say? We offer 20,000 and 30-day suspension?
Which is what I
Counsel's
would,
office said you,
Yeah.
oh, okay.
Okay, 2-2-16.
2-2.
this is over to them?
Yes, for
Yes,
them to
please.
appear.
175.
All right, this is their second sale to non-member, year and a half. I read their letter, offers 1,000 civil penalty, I'll accept.
Accept. 176.
6,000. Second defense.
6,000. 177.
Is it 1,500 or
Mhm.
1,500?
1,500. 178.
Just workers' comp, offer 1,500, accept.
Accept. 179.
They
This is
still
tough.
haven't filed the corporate change application, so they're still availing.
So let's bring them in.
Bring it 2-2. Is it 2-2 or 2? Yeah, 2-2. Right. Gotcha. 180.
I'd counter 4,000.
4,000. Counter 4,000. 181.
So if someone gets an appearance ticket, desk appearance ticket, is that not being arrested?
You're arrested, you just don't go through central
It's a
booking.
criminal, if you get convicted, it's a criminal charge.
If you get convicted, but if you're given a desk appearance ticket, is that considered?
That I don't know.
Yeah, you just don't go through you don't
So
go
you're
through
required to
central
notify
booking.
us.
Yes.
But you still
yes.
notify?
Yeah.
Okay. But do you say you're arrested? No, because arrested is like detained.
No,
No, you're
you received a summons.
Summons?
It's a desk appearance
So
ticket.
it's not
a
arrested.
Summons, it's a misdemeanor
Oh, right,
charge.
DAT, right.
Yeah,
it's
it's
not
a
a-
misdemeanor
yeah,
charge.
okay.
I would say you are arrested.
All right, so
And you've been given the courtesy of not having to go through central booking because you are not a flight risk.
offer 3,500, accept.
Accept. Weird crime, too, by the way. 182 and 183.
Offer 7,500, accept.
Accept. 184.
1,000, offer, accept. Should I have more?
Yes, accept. 185.
Sale for resale, at a count of 2,500.
Counter 2,500. 186.
Offer 2,000, accept.
Accept. 187.
Oh, wait, can we have a moment
Yes.
for conference?
Okay. Let's see then. The council requested we recall 185, so we'll start again with 185. The board had countered with a $2,500.
I'll just accept.
I'll just accept the original offer, 1,500.
1,500.
Okay. Now we're on 186.
I'd suggest a letter of warning.
This is brunch issue. I'll vote for the letter of warning.
Letter of warning.
Got it. 186.
Offer of letter of
Sorry,
warning.
187, yep.
187. Offer of letter of warning, I'll accept.
I'll accept.
188.
Offer 7,000, accept.
Accept.
189.
There's a 2,000 for workers' comp, accept.
Accept.
190.
This is one of those where we either give them a chance by accepting or it's much more serious. He sold
liquor when it was a restaurant
It was
wine.
a restaurant wine, right. It was stocked with liquor. The bar was stocked.
What was it before?
Got his license.
Yeah,
Just
I'm
got his
wondering what
license.
it was before. It wasn't an LP and he didn't know how to dispose?
Yes, that's exactly what he says.
That's what he's saying. So if we believe him, 2,500, I'll accept it this time.
Accept.
Okay.
193. It's a class change.
There's community board support. I was okay with it, but I kind of wanted to know the hours. And then Sunday, I think they have to close at midnight.
They'll stop selling beer at midnight.
Stop selling it.
On Sundays.
At midnight.
On Sundays, it's midnight?
I think
They stop selling beer, yeah, they can stay open.
And wants a restroom waiver.
All right. So I'm okay with it.
I'm okay with it. Do you want to make hours?
See, other hours are on number 9 of the community board letter. It says, operation hours Monday through Saturday, 11 a.m. to 4 a.m., Sunday noon to midnight.
Okay.
Oh. Right. That's what
Oh, wait a minute. That's for Bobby Trop. You said number 9. This place was number.
Oh, I'm
Number
sorry.
8, though.
Yeah.
Number 8, it says approve with no alcohol sales beyond
Oh,
12
that's right.
midnight on Sunday.
I think he gave us all of them
Same
on one
thing.
resolution.
Yes.
Okay. So
So is it 4 a.m. on the other days?
No, we don't know.
we don't know. That's
No,
fine.
do you want to make, do you want to just make the hours?
Just make the hours.
For the other days of the week?
Yeah, I don't
Have
know.
anything in their menu, how long they're
I mean,
open?
they didn't restrict them.
So-
Whereas others, they restricted, so I think I'm okay with
Okay.
4 a.m. It's just Sundays, they gotta close.
It's
Well,
like
he
a real
writes-
restaurant.
Yeah, it looks like a real
Well,
restaurant.
back in 2013, when he applied, he said they're,
Oh, wait, it's
he
not
was
a
going to be
real-
working 3 p.m. to 10 p.m.
I mean, he's right. They didn't restrict them so they can have the hours. Other than Sunday, we'll waive the one restroom.
Agree.
And I just want to make sure there's no DJ. And they have to abide by the stipulation with the community board. Otherwise approved.
People didn't even show up.
Got it. 194.
Okay, just
Yeah.
so
Oh,
you
yes.
know,
Oh, okay, we got it.
you've got 2 package
Oh, this
stores
is
within
it.
a couple hundred feet, so you
Right.
pull 226, I'm sorry, Jeff.
But neither one of them are here.
So why did
226.
neither of them show up?
Neither of them show
No,
up, because
it's-
they generally don't, especially out in.
Oh.
Yeah, they got some snow up that way, too.
Oh, yeah.
So agenda item 194, mailed their application into the authority on November 17th. And 226F mailed their application in on November 18th, 1 day apart,
And how far apart are they from each other?
200 feet.
Literally, like, yeah.
And the
3 or 4.
closest one is 7 miles.
And you've all been to Fillmore, New
No,
York?
11 miles. Next
11
closest one's 11 miles.
I have.
And then that size was 212.25 square feet. You sure?
Oh my God, see, that's the stuff I don't check, I
It's
generally
like
want to trust the
212.
examiner.
And then this one doesn't even have the size.
212.25?
Yeah, is that right?
I think that is on their,
Oh, really?
on their gross sales. I mean,
212.
we didn't check it back to.
212.25. So I think the closest one is 11.1 miles away. It seems if this 212.25 square feet is the accurate size, it's a very tiny footprint. And then the closest one after that is 15.2 miles away, and that's 1,800 square feet. Sales have been generally increasing for the nearest stores. The two are very close to each other. Huh?
Saying 322 feet.
Oh, 322 feet. So it is a small footprint. And 194, the proposed space is 2,400 square feet, whereas 226F is only 404 square feet. So I would approve both and allow them to decide if they're going to open up.
Well, the market decide.
Well, the market will decide, but one of them might decide, oh, I don't want to open up if the other one's opening, but that's up to them to decide. But I will vote to approve both and let the market decide.
I'll vote to approve both as well, based on that conclusion. There is clearly not a liquor store within a lightning bolt away, and so I don't see them affecting anybody's sales except their own. And it is a small village, and so I guess they both have a decision to make. So they're both approved.
196.
Offer 2,500, accept.
Accept.
198.
Offer 2,500. I had a counter of 4,500. It's the second offense, and then also that he refused to answer questions.
I actually had a counter of 5,000.
5,000.
For being uncooperative, and it's a second gambling.
Right.
199.
It's an offer of 9,000. I'll accept it.
And they're asking for it to be lowered.
They offered it, and then they're asking it to be lowered?
Correct, and they paid $8,000 last time.
But 198 was, and that was was
Sorry,
25.
Because the
199.
8,000, they had
They
a
must have had
prior.
a bad history.
99, Chairman.
No, but well, I'm just comparing, I know they're not the same, but it's the same offense.
No, but I think this other adverse history, we're
There is.
missing the most recent 5.
Oh, okay.
But I'm sure
They
there's a
had
lot more.
Gambling in 2006, gambling in 2009, gambling
Oh, I
2010,
see. So this isn't just a
2015.
second offense.
Yeah.
Okay.
So, I mean, I'll take the 9,000.
9,000.
With that history.
200.
They're going to gamble, somebody's making money off it, that's going to be
Yeah.
us.
So this is like 2 years they had no receipt from Empire, 3 years from Southern. Seems low.
This is a really
It is low.
sad case, though.
Yeah, their last penalty was $5,000 with the 20-day suspension for the same thing.
His daughter was the bookkeeper. She clearly got extremely ill and died. Is that correct? So all this was going on while he was caring for her.
All right. Where's that?
That's why I was willing to go lower.
Go lower?
No, not lower than that, but
Take the offer. All right. Take
5,000.
Given those circumstances, accept 5,000.
Except 5,000.
Yes.
201.
Okay. Offer 4,500. I'll accept, but they need to file for an OP, right? Because they're obviously not.
Say
There is a class change pending.
Oh, there is. Okay.
I'll accept.
202.
Offer 3,000. Accept.
Accept.
I'm not sure, is that the one you were talking about, Jackie?
Yes.
Okay.
I'll speak to Noel.
203.
Offer 3,000. Accept.
Accept.
204.
Cancel and bond.
Cancel and bond.
205 and 6. The
Offer.
alteration application was recently denied for failure to comply.
Were they going to change the hours to close by 1 a.m.? Or they did? Or that's what's been denied?
No, the alteration for the patio enclosure.
Okay. I'll accept the 10,000, but they're closing by 1 a.m., right?
Yes,
Is that
it
on their
seems-
license?
Closed by 1 a.m. You need a serial number, Care?
Yeah, and licensee agrees to file method of operation change to have last call 12:30, close at 1 a.m.
Which one is this one?
This is
205 and
205 and 206. They said they would do it.
And they're closing at 1 now, and it seems to have alleviated most of the
Right.
noise complaints.
So that's why I think we gotta add that. It's 10,000 plus last call 12:30, close at 1.
Yeah, but I think you might have already filed, that was the endorsement.
Oh, all right.
Yeah, it was approved.
Okay.
So,
10,000.
10,000.
210.
It's like, keep close. I mean, offer 4,500, but their steps, number 4 was like, we'll do our best to do this, to keep their interior doors and windows closed. I just want it to be that they will keep their windows closed, not best effort.
I like the fact that they were hiring somebody to look over the parking lot, because I've never seen that somebody come here and say that, and they always just say, it's in the parking lot, we can't do anything about it.
Okay, 4,500, accept.
4,500.
211, I have a request to adjourn. They were getting documents, which they just received, I believe opposition. So that's for 2-2?
2-2.
It's 2-2.
213.
Offer 3,000, accept.
Accept.
214.
This is the 3 16-year-olds to get some reduction. I mean, dismiss 2, offer 5,000, accept.
Okay, 5,000.
215, I have a request from Attorney Fogelman to adjourn.
2-2.
2-2. 216 through 218.
Offer cancel and bond, accept.
Accept.
Fine, nice.
219 and 226A.
Update. We're supposed to get an update on the security plan, I think? Oh, these are charges from so long ago.
2011,
Yeah.
yeah.
So I think my thing was, I just wanted to see an update on the security plan. No.
It wasn't on before.
It wasn't?
No.
No.
Right, what I'm saying is all these charges were from so long ago. I mean,
Although we weren't getting any referrals.
we haven't
from
gotten
them.
since? Okay.
Now, I'm pulling it up right now to see if there's anything else,
Yeah,
but
let's
they
just-
weren't sending us the referrals.
If there's nothing else, I'll accept the 12,000, 'cause it's been a while.
We have a sale case 84, that's this, yes, we have nothing else pending.
Okay, I'll accept
this time.
12,000.
Accept.
Oasis, this has been going on forever.
226.
Wasn't this for the licensee to
Yeah,
appear?
they were supposed
Yeah,
to
it was
come
to
in.
appear.
Cancel and bond.
Cancel and bond.
Well, it says CNC.
I
So
know.
counteroffer, cancel and
Counter,
bond.
cancel and bond. He's not, the last one, we asked him to come in, right?
Right.
Yeah, so counter, cancel and bond.
226B, there was a request, I had got an email, I'm not sure
What
what
are
they
these?
requested, hold on.
It was for proof
We're
of
waiting for
food.
pictures. This can't be so complicated.
Hang on, poor.
Wait, this one we've adjourned to multiple times,
Let's see,
right? 1, 2,
we have, oh, they
1, 2,
provided,
3 times.
I got to an affidavit, which I can't even read.
There's still no food here?
Hang on. Blow it up. Affidavit from the general manager, directed to appear at the, yeah, blah, blah, to provide proof that food is available all hours, I cannot appear, I have childcare issues, blah, 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 blah. I'm willing to appear on any other date, as I have had in the last 2 weeks, as I have at least 2 weeks' notice before they can appear. With respect to food prep area, I've submitted photos via Amy Chaplin of the food prep area. We have updated the equipment in the area, and we are serving food during all hours. So maybe the attorney has the photos.
I'll look in the system right now.
If they were scanned in, you probably can't read it.
Can't see them.
Let's, well, we called him in and he didn't come in, right? He's looking for another day?
Yeah, we're gonna have to tell them that, yeah,
All right,
it's 2-2.
2-2.
Last one.
Well, but he did get in touch with us?
We received an email.
Okay.
Make sure it gets sent back. How about I have them just resend photos
Yes.
to my office? $226D.
This is, I've revoked and bond.
Revoke and bond.
You want to dismiss charges 8, 9,
and 16?
Yes.
Yes, dismiss 8, 9, and 16, sustain all the other charges, revoke and bond.
Got it. 226G, I had a request to carry over due to inclement weather today. To 2-2?
Okay.
What?
In Syracuse, they got over a foot of snow.
The
representatives from Schenectady.
Schenectady got a foot of snow?
Syracuse.
Oh.
Representative, former Chairman Boyle, is in Syracuse.
Oh, okay.
Oh, he's appearing?
guess.
Oh, I
Yeah.
get to. I finally get to meet him.
226,
By video. By video.
226K.
226, let's see, twice denied for not filing application properly.
God, Syracuse hadn't had any snow.
Lake effect.
This.
No, I mean, it's just, but they just got
Yeah,
dumped.
no, they just got a ton.
You okay with this? Yeah? All right. I approve.
Recorded music, no dancing. I approve. No DJs though.
Adding it in.
That's the theme for today. No DJ.
All right, 226L.
It's only 565 square feet, closest is approximately 13 miles, and that store is only 798 square feet. Looks like sales have been either flat or increasing for 3 out of the other 6 stores. Yeah, I vote to approve.
I approve as well, based on the distance to the nearest store, which is, as Commissioner Kim pointed out, 12 miles away. I can't imagine it can't be more convenient for the residents of that area to have one closer.
And 226M, I had a request to carry over to 22. Everybody's traveling.
2-2.
2-2.
Everybody's traveling.
I have no other items.
So let me ask you, our Silverline Lounge, we already did?
Yes, that was, yeah.
Pat's Palm Tree, we already did?
We did, they came in.
And JMN Express Deli, we did?
Yes, that was a confusion.
Okay, we're adjourned.